Yes.
My lord, I beg to mention item number 4 of the hearing list, my lord.
Yes.
My lord, I pray that this matter may not be taken up only for today, my lord.
Item for hearing.
Yes, my lord, hearing list, my lord. WPC 1806 of 2013. Only for today, my lord.
Okay. Okay.
Obliged.
May it please, Your Lordship. Your Lordship, I beg to mention a matter for listing on
Listing,
Friday.
give it to the court master. He'll have to make some adjustments 1 or 2 days, but he'll do it.
Obliged.
Our place for listing, give it to the court master. Yes.
May it please, my lord. I beg to mention a matter, unlisted matter for listing. It's there is an urgency in the matter, my lord. What happened in the matter is that eviction drive is going to be carried out, and my brother is a partially disabled person. My lord, it will be very difficult for us if the eviction is carried out. We are contemplating that. If it may kindly be allowed today, during the
Okay.
course of the day,
Okay.
highly obliged.
Please, Your Lordship. My lord, this writ petition has been preferred against the letter dated 29/5/2023. Kindly come to page 88 of the writ petition, madam. My lord, is there?
That's all. Page.
Page 88, annexure 6. I'm reading it, madam. To all divisional forest officer under Karbi Anglong, subject eviction in Doldole Reserve Forest and Lahore region proposed reserve forest. Reference this office letter numbers so and so, dated 22nd May 2023. In continuation to this office letter number cited above, on the above quoted subject, it is made clear once again that Honorable Chief Executive Member KAC had categorically directed that eviction.
You, Mr. Borgohain? Yeah, Mr. Borgohain.
My lord.
Mr. Borgohain, you see, this, are you aware of the manner in which demarcation cases are handled by the Office of the Deputy Commissioner? Are you aware of it?
My lord, I'm not getting your lordship.
This demarcation case
My lord.
before the Office of the Deputy Commissioner,
My lord.
can you tell me what is the procedure?
We have to make an application, my lord,
Okay.
under the rules, Assam Land Revenue Regulations, my lord.
Yes.
Then they will be issuing, they will send a mandal for survey in that area. And from their records and our records, if they will tally it up. If their telling is not there, then they will ask for an explanation.
Okay. In this case, where is your application
My
for?
lord, your lordship, what happened in this matter? A writ petition was filed. And accordingly, a direction was issued by this honorable court on 18/9/18,
Yes.
asking for the KAC. My lord, page 84.
Yes.
Page 84, operating portion is that, my lord. Page 87. Page 86.
Yes.
Para 9. Accordingly, this writ petition states disposed of by providing that the respondent in the KAC shall not indulge in evicting the petitioner from his declared patta land without following due procedure of law, which again would mean that there shall not be any bar on the part of the KAC authorities to evict the petitioner from any land other than his patta land, which may be under his occupation, be the land within the forest area or otherwise, and in doing so, the authorities would follow the procedure of law. Para 14, my lord. It is stated that in the resultant process, the respondents are not allowing the petitioner to construct his residential structure of his patta land. To that extent, it is provided that the respondent in the KAC shall undertake a survey and identify the patta land of the petitioner and demarcate it. Upon doing so, shall not prevent the petitioner from undertaking any construction of his patta land upon such demarcation being made. In terms of the above writ petition stand disposed of.
Yes.
My lord, in pursuance to what this, my lord, let me put the facts in this way. I was not aware of. I made my representation, my lord. I have made my representation. There was already a communication from the concerned authorities for demarcation, my lord. Now, what happened, my lord? On 29/5/2023, this order was being issued. I got the copy of the order on 3rd. This order through WhatsApp, my lord. Then we filed a writ petition on 3rd, asking for the immediate stay, because this exercise they have done. I don't know under what law they are even exercising this power, my lord. And your lordship will kindly come to page 89, annexure 7. They have deputed these officers for carrying out the eviction. Now, my lord, my humble submission is that, provided that they want to evict me, if I take it from their point of view, there has to be a procedure, my lord. They have to demarcate me which land I am. There has to be a notice has to be issued to me that under particular provision. They have not done anything, my lord. It is a Damocles sword is hanging over my head. And they are saying that they will evict today. I am unable to come to Guwahati to meet my lawyer and have a due consultation also. I sought some papers as a counsel. I sought some papers. He has sent me in WhatsApp. Your lordship will kindly see. My lord, kindly see 88, annexure 7.1, annexure 6. Is it the order for eviction or is it threatening to the officials of
Page.
page 88, annexure 6? My lord is there. In continuation, this office letter number cited above on the above quoted subject, it is made clear once again that Honorable CEM KAC has clearly directed that eviction will start in Dudu Colony, etc. in the revenue land, followed by Lahorijan RPF, PRF on 3rd/6/2023, followed by eviction in Doldoi, RF on the same day. Jointly by Forest and Revenue Department, KAC, eviction shall continue in Doldoi, RF on 4/6/2023. Also, and the entire RF shall be freed from the classes of the encroachers by the evening of 4/6/2023. There is no confusion in this context. However, this office has been receiving correspondence from some DFOs which is not in tune with the instruction of the Honorable CEM KAC. Please note that any deviation from the instruction of the Honorable CEM KAC will be viewed seriously and personal responsibility will be fixed accordingly, followed by departmental action.
Yes, Mr.
My lord,
So
the
there-
eviction, my lord, is in the reserve forest. Whether the petitioner have any right over the land of the in the reserve forest. My lord, Assam forest regulation is clear, my lord. Assam forest regulation.
My lord will go through. I'm just assisting my learned senior. There's a process. And the regulation number 5. A proclamation is issued. My lord, and my lord, in that context, the judgment of this honorable court is also I'm holding a judgment. When does right accrues, my lord?
Lordship will look into, my lord, section 3(5) that defines forest offense. Section 3(5). And it is, my lord, declared as forest reserve on, my lord, only on 14th October 1969, my lord. This is the gazette notification. And the boundary is also demarcated, my lord, in the serial boundary is also there. My lord, the petitioner does not have any right, my lord, any right over the land, my lord, which is declared as a reserve forest in 1969 itself, my lord. And if any persons, my lord, entered in the reserve forest, my lord, so, my lord, the authority has the power to evict, my lord. That is under section, my lord, 61, section 49, section 63.
Section 49 of the Forest Act.
Forest Act, my lord. Now, before that, my lord, lordship will look
No.
into section 3(5), my lord. What is forest offense? Forest offense means an offense punishable under this regulation or any rule they are under, my lord. Then lordship will look into section 61. Then section 61, power to prevent commission of offense. It shall be the duty of every forest officer and police officer to prevent, and any such officer may interfere for the purpose of preventing the commission of any forest offense.
No, but you see, Mr. Sutia,
My lord,
you and Mr. Gogoi,
my lord,
when there is a previous order of this court,
My lord.
18/9/2018,
my lord.
at least for the petitioner, you will have to say that this is a forest land.
My lord, now the proposed action is required to be taken, my lord, is to be, my lord, evicted from the forest land, not from the periodic pata land. It is, my lord, it is clear from the, that, my lord, annexure, page 88, my lord, it is only for eviction from Doldoli Forest Reserve and Lahore Reserve proposed reserve forest.
Which page?
Page 88, my lord, subject, my lord. It is clear, my lord, it is not from the periodic pata land. Eviction in Doldoli Reserve for subject, eviction in Doldoli Reserve Forest and Lahore Reserve proposed reserve forest. It is from the reserve forest, my lord, not from the periodic pata land, my lord.
Now, what is a proposed reserve forest?
That is, my lord, that under the Karbi Anglong Forest Act, my lord, Karbi Anglong has also the power to, my lord, as per the constitution, have the power to declare the reserve forest. Accordingly, 1969, Lahore Reserve Forest is declared as a reserve forest, my lord. The forest, my lord, other than the reserve forest, is the inherent subject under 6th schedule, my lord, of the constitution. So accordingly,
If you are doing with regard to, on the basis of this 14th October 69,
my lord,
then your action has to be stayed. You see, this is merely an objection, seeking all claims and objections
my
to,
lord,
to make it a, to
my
make
lord.
it a proposal.
Thereafter, my lord, in 1969, my lord, that has been declared as a reserve forest, my lord.
Where is that?
My lord. Lordship may look into it, my lord.
This is only a proposal.
No, my lord, thereafter, my lord, it has been declared as a forest reserve, my lord. That is our act, in our, as per our act, my lord. Page 29, my lord. Page 28. And it is received the assent of the governor on 25th November 1957, 4 December 1957, 25th November 1957. And as per the act, my lord, we have the power, my lord, autonomous council have the power to make law in the, to declare the reserve forest. Accordingly, my lord, that notification or gather notification was published in that time, my lord. And section 7 is there, my lord. Council Forest Board to dispose of claim and objections. If they have the claim and objections, my lord, if any person who research in a forest, then they can submit the application within 90 days, my lord.
No, but you see, when you are showing me this, this section 8 and 10
My lord,
must be followed by you.
my lord. Preliminary notification constituting reserve forest,
Yes,
my lord. And they have
that as well as under 10, final notification. It
My
must
lord.
come.
final notification constituting forest reserve, my lord.
Yes.
My lord.
But till it is not there, you can't go proceed with the eviction.
My lord. আমি কইছি
Because if you want, we can take it up at 2 o'clock, but unless there is a notification, there can't be a presumption of.
But it is the ERF means the proposed reserve forest, my lord. That is under the within the, my lord, that notification issued in 1969 claiming objections that it should be declared as a reserve forest, my lord, by the autonomous council. And if you lordship look into the constitution, my lord, 6th schedule, my lord, that is the power, my lord, given under the 6th schedule.
Proposal is only a proposal.
My lord, if it is also, my lord, if it is also proposal, whether the petitioner have any right over the forest, my
Yes,
lord,
he'll have a right.
in the reserve forest, my lord,
No. According to you, it is proposed.
my lord. But,
So till the
without
date it
any,
is.
my lord, without any patta, whether the petitioner have any right over the, my
That is
lord,
why this
land.
court said that you declare it, you can demarcate and then say that this is a
My lord,
forest land.
that is in respect of the periodic patta. Lordship may look into that order, earlier order passed by the Honorable High Court, my lord.
No, you see,
Before that, Lordship may look into, my lord, page,
no, you'll have to take a stand, Mr. Sudhia.
my lord.
First stand will be that you'll have to make a statement before the at the bar that none of this periodic patta land forms a part of your proposed reserve.
My lord.
You see,
My lord,
because
My lord,
if
it is the case of the petitioner, my lord, it is the case of the petitioner. They have annexed the document in the petition that they are resident of the village Nahurjan block number 1. Lordship, earlier also, this honorable court protected them from eviction on the last, my lord, earlier week also, Lordship passed the order protecting from the eviction from the periodic patta land. And Lordship will look into the annexure 3, page 81. They have annexed other patta, my lord, of the Nahurjan block number 1. I'm not on that, my lord, periodic patta.
yes,
The page 81, annexure 3.
yes,
The Assamese version is that 82. All are the Sarkari land, my lord. They have annexed this petition, my lord. 85 because of Sarkari land, government land. Whether the petitioner have right over that land or not, my lord. It is their own case, my lord. By annexing that document, it is clear that they are encroaching the government land. And for eviction of the government land, my lord, no notice is required, my lord, if it is reserved. And if you lordship 82, my lord, next column, my lord, it is not clear, my lord, but name of the petitioner is there as a Dokhaldari, I think. The word is there. And in the
though is
Dokhaldar, but it is not the APP, it is not the word APP. In the translation, they wrote it as APP. Page 81, annexure 3. Remarks column, APP. There is no APP, they are the, my lord, the Dokhaldar, they are the enclosures.
No, it can be Dorkhastokari also. Dorkhastokari will not be there, it will be Dokhalkari.
Dokhaldar, that may be, my lord, but
Dorkhastokari.
that they have only part of the, my lord, annexing.
Yes, yes.
Dokhaldar, it is
Dokhalkar.
Dokhaldar, my lord. But as they have the annex own document, but the other documents are the periodic patta lands they have annexed, my lord. But that is proposed, my lord, from the reserve forest, not from the, my lord, periodic patta land. Lordship may record by that statement, my lord. Eviction from the reserve forest, not from the, my lord, periodic patta, my lord. And on that day also, my lord, Lordship has passed on the basis of the my lord, notification furnished before your lordship. In that particular case, my lord, Lordship will look into that WPC number, my lord. WPC 3120/2023. Your lordship passed an order, my lord, on that day.
So that's WPC.
WPC 3120/2023. Your lordship passed the order on 36, 2023. This side. 31. 31.5.
Yes, Mr. Govil, what do you have to say?
I'm just supplementing the view of my senior. But two land in questions are there. One is PRF lordship is very correct. That PRF, my lord, there is an issue. But as a RF, my lord, what I was insisting on the judgment of this High Court, of this Honorable Court, my lord, will kindly take up the judgment. My lord, there is a procedure laid down in the regulations which has been adopted by Kabi Angalam. Lordship will kindly go to para 15 and 16, my lord, of the judgment.
Which judgment?
I have given one. I can give another copy.
This
Yes,
one?
Yes, my lord. Yes.
Dashrath Yadav.
Yes, my lord. My lord, 15 and 16 are pertinent, my lord. Now, my lord, 15 and 16.
Yes.
My lord, now the question, it starts. Now the question before this court is as to whether the authorities are justified in not recognizing the rights of the petitioner in respect to the land in question. And in regard, it will be relevant to take note of section 21 and 22 of Assam Forest Regulations, which is quoted herein below. Well, it is quoted acquisition of rights and right under reserve forest. No right of any description shall be acquired in or over reserve forest except by succession or under grant or contract in writing made by or with the previous sanction of the state government or the some person whom such right or the power to create such right was vested when the notification under section 17 was published. 22, alienation of rights. Alienation of right in reserve forest, notwithstanding anything contained, no right continued under section 13 shall be alienated by grant, sale, lease, mortgage, or otherwise without the previous sanction of the state government, provided that when any such right is continued for the beneficial enjoyment of any land or building, it may be sold or otherwise alienated with such land or building without such sanction. The benefit of any right continued under section 13 shall not be leased, sold, or parted except to the extent defined by the order recorded under that section.
There's no difficulty in understanding this.
Yes,
so far
also
as reserve-
16, my lord, 16.
Reserve forest is concerned,
Yes.
but if it is only proposed,
Yes,
then the right of the petitioner can't be taken away.
yes, but 16 also takes care of it, man.
Yes.
They have to file objections. And here in the case of the petitioner, very clear. My lord, let's see the synopsis. He goes, my lord, he takes in possession a large plot of land and he leases it them. He has lessees. And also, my lord, to the extent he names the village in his own name. That's my issue, my lord. And apart from that, my lord, I am holding this Godawaran judgment. Godawaran judgment, my lord. Citation the key. Goda?
No, all this would have been a wonderful argument if it is a reserve forest.
No,
But for-
my lord, as regards, there are two disputed lands, my lord. One is PRF, one is RF. I am submitting as regards of RF, my lord. Dondoli,
No, RF is not, there
Yes,
is no
but-
issue with that.
my lord,
In reserve forest, there is no issue.
my lord. My lord, para 4 of the judgment. The Forest Conservation Act so and so was enacted with a view, my lord. I'll skip. The word forest must be understood according to the dictionary meaning. The description covers all statutorily recognized forests, whether designated as reserve, protected, or otherwise for the purpose of so and so act. The term forest land occurring in section 2 will not only include forest as understood in the dictionary sense, but also record as forest in the government record, irrespective of the ownership, my lord.
Yes, so far this is concerned, there is no dispute with that.
Yes, my lord. As regards, my lord, this is as regards RF, my lord. Dondoli.
Yes.
PRF, my lord, my learned senior has to convince this court. Apart from that, my lord, there's a Forest Conservation Act. Conservation Act, my lord, section 2. It reads, my lord. May I read, my lord?
Yes.
It's a Conservation Act says, my lord. It's a Act of 1980. Restriction on de-reservation of forest or use of forest for non-forest purpose. Notwithstanding anything contained in other law for the time being in force in a state, no state government or authority shall make except with the prior approval of central government may order directing that any of the forest land or any portion thereafter may be used for any non-forest purpose, my lord. As regards Doldoli, my lord, RF. That is my submission.
if your lordship permit, can I clear
Yes.
two aspects? My lord, what I have understood from my colleague's argument as far as KAC is concerned, they are saying that they have the power to make law on forest that is reserved forest. Your lordship, kindly come to section 5 of the Assam Forest Regulation, my lord. Kindly come to section 5 of the Assam Forest Regulation. My lord is there?
Yes.
Section 5. Notification by state government of proposal to constitute a reserve forest. Whenever it is proposed to constitute any land a reserve forest, the
Oh,
state.
don't worry, this is a transfer subject for the, so far as forest is concerned, it's a transfer subject.
My lord.
So don't,
No, my lord, what I'm saying is that this issue that whether Karbi Anglong or autonomous councils formed under 6th schedule has the power to regulate reserve forest or propose reserve forest. This has been settled by this court two decades back, your lordship. Kindly see that judgment I'm putting it. Where this court has categorically held that you cannot do that. My lord, the judgment is. He'll indicate below. That was with respect to North Kachar Hill Autonomous Council, minor. Both were formed at the same time. 6th schedule, your lordship. Kindly come to para 12. Para 12. May I read it, your lordship?
yes,
But such executive power of the district council will be subjected to the 3 limitations indicated in Article 162 of the Constitution. 1. Such power will be subject to the provisions of the Constitution. 2nd, such power will be subject to and limited by the executive power expressly conferred by the Constitution upon the Union or authorities thereof. And such power will be subject to any and limited by the executive power expressly conferred by any law made by Parliament upon the Union or authorities thereof. Such executive power of the district council will also be subjected to two other limitations. Number 1, such executive power will be subject to the provisions of any existing law or any other law relating to reserve forest made either by Parliament or by the state legislature or by both because of Article 256 of the Constitution. And because the district council has no power to make law in respect of management of reserve forests under paragraph 3(1)(b) of 6th schedule. And number 2, such executive power will be subject to the conditions, if any, imposed by the governor while entrusting the executive function in relation to forest or reserve forest under paragraph 6(2) of the 6th schedule. The net result of the aforesaid discussion is that the executive power of the council in relation to reserve forest will be subject to provisions of the Constitution, law made by Parliament, including the Forest Conservation Act 1980, law under by the state legislature, and the Assam Forest Regulation 1891. So, my lord, what I am trying to impress upon this lordship is that they are saying that it is respect to a forest, proposed forest reserve. My lord, whether they have the power under paragraph 3(1)(b) to call or to declare a particular area for a proposed reserve forest.
you know the background of this case, why this litigation was originated, you know that?
My lord, with regard to bamboo, that one, not Kachar Hills.
No, there was a prayer before the court
My lord.
that since the autonomous council gave them the license to trade in bamboo,
My lord.
therefore there should be a direction that the transit passes for this be issued.
My lord.
In that context, this court says
My lord.
that the power is subject to the power under the Forest Act. So when under the Forest Act, the Assam state has banned the movement of bamboo. So it will be covered by that. So it is only interpreting that.
My
It
lord.
doesn't say that under the transfer subject, the reserve forest would not be under the control of the autonomous council. That they have already done. In this case also, they issued a what you call the license to trade
My lord,
on bamboo.
your lordship, what I am trying to impress is that as far as the paragraph 3(1)(b), they are saying that they have a law to make. I don't know where, I don't have the copy of the law because it's very guarded secret, my lord. To be very frank, your lordship, I don't have a copy of the law. What
Which law?
this regulation, what they are saying, 1969 Karbi Anglong law, also, I don't have a copy of that.
Oh, that is our gazette notification.
My lord, I don't have it. I tried to
No,
check
no,
it.
you may not have it. but doesn't mean that it is not in the,
My lord, what
Public
I'm saying
domain.
is that
Hmm.
as far as proposed reserve forest is concerned,
Hmm.
even if we say that they are going to do it, my lord, the first question is that they has to publish in a gazette notification first thing, and the proposed reserve forest exercise is a time-bound exercise, my lord. And because for that, if there are eviction is there, you can evict them. But for that, you have to demarcate the land. And even after demarcation, if the persons are sitting in that land, you have to acquire the land as per the Land Acquisition Act, 1894. Now, my lord, what my second argument is that they have issued this order. It's a blanket order, my lord. Let them come up with the specific instructions, my lord. Which land? Because I have got my instruction, my lord, that the land which I am occupying is a periodic patta land, and there is already a process has been initiated by the authorities themselves to allot me the land also, other lands, which were a subject matter. But till date, they have not issued it, but there is a communication from 2019, 2020. Let them come up with a proper instruction, my lord, why they are going to evict me, what is the scope, under what law they are going to evict me, my lord. Because this notification is, this order is a blanket order, my lord.
we will be protected only from that proposed.
Eviction,
what you call
proposed
it?
reserve
No,
forest,
no,
my lord.
proposed reserve forest if it is not a government land. But if it is a government land, then you will not be protected.
My lord, as far as I am concerned, my lord, as far as I am concerned, let them come up, let them come in the next week to, on tomorrow itself or day after tomorrow itself, that this land belongs to me, this land does not belong to me. So that, because in the vex that this is not a government, this is a government land, if they evict me and tomorrow it comes contra. So at least to that effect.
Then you will be put back.
What am I, lord?
Then you will be put back. But if it is a government land, you will not be protected.
My lord.
But
My lord, may
Mr. S. Borgoyal and counsel for the petitioner, Mr. Oh, yes.
my lord, may kindly peruse page 81, lordship. 81, the view already lordship has taken, lordship. Page 81, Sita for surveyed place, lordship.
Yes, Mr. Borgoyal.
It is a lordship government land, lordship.
Hmm.
Admittedly, it is a government land, lordship. And petitioner also not disclosed here before the honorable court,
My lord.
how much,
Yes, sir. Please.
how much land he has, lordship, encroached, lordship, or how much land he has in his custody, lordship. In lordship, it is a government land, is admitted fact, lordship. Even lordship, it is a lordship, PRF also, lordship. PRF also, he has no right, lordship, proposed reserve forest. If PRF proposed reserve forest is there a PRF in respect of government land, lordship. In respect of the periodic patta land, lordship, then he has the right, lordship.
He is claiming only right on the Patta land.
So, lordship, it is admittedly, it is a lordship, government land, lordship. Even lordship, PRF also, lordship, he has no right, lordship. And in case of government land, lordship, we can, lordship, forfeit eject him, lordship, if it's necessary for us, lordship. Lordship.
May I clarify on page 51, your lordship, what they are referring to. Your lordship, that was a part of the record in the earlier petition, which has been annexed. On the basis of that document, this honorable court directed that you do the demarcation. And accordingly, we presented our application. There were orders also issued by the KAC, but till now they have not issued, they have not demarcated the land. And even this aspect, this land, government land, which they are saying, of course, it is there on the record, my lord. That already it has been, process has been initiated by the KAC.
Don't worry, because you see this, if it is a forest land,
My lord.
then it's mandatorily under the orders of the Supreme Court. Every forest has now been documented with regard to this latitude and longitude.
My lord.
We have what you call what do you call?
Geotopographic map, my lord. This
What is the term?
geotopographic map, like all the latitude, longitude.
So
GPS,
whatever,
GPS, it's basically by GPS, my lord.
whatever is that, but I don't know the actual term, but it has already all been codified.
My lord.
So therefore, we will ensure that you are not evicted from any patta land.
Lordship.
That protection you will get.
Lordship.
My lord, if your lordship may kindly direct me, or direct my colleagues to the law which they are referring, that a copy of that be given to us, my lord.
We will give it to you.
My lord, we have tried our best.
It's a gazette notification, lordship.
We-
It's accessible
Okay,
for
he will
everyone.
have- he will pay.
Yeah, accessible for everyone, lordship.
If a lawyer says he doesn't have,
Lordship.
you can always.
Lordship, we can provide them.
Yeah.
Otherwise, the government land, admittedly, lordship, in the government land, he has no right, lordship.
Mr. Mr. Gogoi, you'll be appearing for whom?
I'm appearing for petitioner, my lord.
No,
I am for option 1 and 4 option.
1 and 4. Mr. J. Sudhir, Lawrence, standing counsel for AAC, appearing for respondent number 2,
3,
3,
5, 6, 8, 9,
Right.
10. 10 and 11 is the my lord same person. Same party. 10 and 11 is the same.
10 and 11 are same. Oh, okay. It is submitted that respondent number 10 and 11 are same. And Mr. D. Goel, standing counsel for respondent number 7. Next, Tara. By filing this repetition under Article 226 of the Constitution of India, the petitioner is seeking quashment of the letter dated 29/5/2023 issued by the
Special principalship conservator forest.
especially by respondent number 8. Concerning eviction. No, what is this? And list of eviction. What is this list of eviction?
My lord, this list of eviction is the group, the person they have authorized
The officer entrusted for
For eviction. for carrying out the
The
eviction. These are the
eviction.
persons authorized to oversee the eviction. As
Okay.
far as I am concerned, my lord, it is at page 18-9, Group A, AK Model Village, Mr. Pranab Tena and Patro Senar, ACF and the Forest Ranger.
Which one? Serial number 1. Page 89, serial number
Yes, only one, my lord. 89 serial number 1.
89, this AK Model Village.
Yes, my lord.
Which is sought to be carried out in AK Model Village. Next part. In brief, the case of the petitioner is that the predecessor in interest of the petitioner had settled in Nahorjan, NAHORJAN, block number 1, Moza Borjan, district, circle Difu, under Karbi Anglong and Roms Council, and the whole periodic part of land. And the model village set up by him is under the name and style of Kramsa, KRAMSA Model Village, and also known as AK Model Village. Full stop. Alleging that the petitioner had grabbed forest land, an eviction drive was initiated previously on 27/11/2017. And the petitioner had approached this court by filing WBC 2545 of 2018. And this court, by order dated 18/9/2018, observed and held as follows. page 86, para 9 to para 14.
Para 7 also last line, man, we're looking, para 7. There cannot be any bar from evicting the petitioner from such land.
Para 7 onwards, 7 to page 86, 87. Next para. The learned counsel for the petitioner has submitted that till date, boundary demarcation was never carried out by the respondent authorities in terms of the order dated 18/9/2018 passed in WBC 2545 of 2018. Full stop. It is submitted that once again, an eviction drive has been initiated by virtue of a letter dated. What is the date of this letter?
Letter dated
88
29/5/2023.
29/5/2023. This topic is submitted that no individual notices have been given for carrying out the eviction drive. And it is submitted that they said the content from the contents of the said letter, it appears that it is a warning to the concerned officials to carry out the eviction drive within the prescribed timelines. Hence, it is submitted that the manner in which the petitioner sought to be evicted is illegal and arbitrary. Next paragraph. The learned senior government advocate, additional senior government advocate, against Mr. Gogoi, right, additional senior government advocate, learned standing counsel for the Karbi Angla AKAC, and the learned standing counsel for the State Forest Department, supplementing each other. Have submitted that there was a notification dated 14/10/1969 was issued by the Karbi Angla Autonomous Council, by which the land proposed in the schedule to the notification was proposed as reserve forest. Full stop. It is submitted that it is submitted by referring to the provisions of which page was that?
Page 20.
28. By referring to Meeker Hills within bracket Forest bracket close Act 1957, which received the assent of the Governor of Assam on 25/11/1957 and published in the Official Gazette on 4/12/1957. The Karbi Angla Autonomous Council had the power to constitute reserve forest.
Council is the first. Take the 3.
That's what I'm saying. Constitute reserve forest at the disposal of the district council, which would be such forest which are not otherwise covered by the reserve forest under the Assam Forest Regulation, 1891. Full stop. It is submitted that the power to constitute forest is prescribed under section 3 of the Act. And the exception clause is provided for in section 1 within bracket 2 of the said Act. Full stop. It is submitted that where did you show that this irrespective of ownership? Where is that?
This is a government judgment, my lord, era 4.
Okay,
Era 4.
referring to the
1997.
decision of the decision of the Supreme Court of India in the case of T.N. Godavarman, Godavarman, Thirumur, THIRUMULKPAD versus Union of India and others, within bracket 1997, bracket close to SCC 267. It is submitted that that in para 4 of this judgment, the Supreme Court of India has included in the definition of forest land, not only to include inverted commas forest as understood in the dictionary sense, but also any area recorded as forest in the government record, inverted commas, irrespective of the ownership. Inverted commas. This Dashrath Yadav who was cited, for what purpose? Just put on your speaker.
It speaks about bar of equivalent rights, how rights are acquired, how forests are notified in para 15 and 16, madam. Is there, madam. 16 was more relevant, madam, as regards two lands are in dispute. One is clearly a forest, reserve forest, which is admitted by the petitioner also. 16, madam.
Okay, it is submitted that insofar as that if a land is a forest land, the rights of the persons holding the reserve forest land is only limited to certain rights vested under the forest dwelling schedule. No, sorry. What is the name of that act?
ST similar for it was
The right of forest dwellers, so and so. Sorry, it is the scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights bracket close rules, 2007, and the act is 2006. Name of the act is same, scheduled tribes and other traditional forest dwellers, recognition of Forest Rights Act 2006 and Rules is 2007. Except for which no right would apply to any person. And for the said purpose, the decision of this court in the case of Dashrath Yadav versus the state of Assam and others, WPC 7-60 of 2015, decided on 19/1/2022, was cited.
Humbly, madam, para 16 is also very important.
What does it say?
It says, madam, when a forest is notified, madam, preliminary notification is given under section 5 and regulation 5, then my lord, objections are taken. And after that, my lord, if somebody has any right, my lord, that is decided upon. And after a period, my lord, that right also lapses if doesn't have any substantiating rights. Para 16, madam. After publication of notification, final notification of
What is the
regulation.
final notification? Why should I write whatever you say?
Right.
You are not showing me that type.
Well-
You are wanting me to record your argument.
My lord. I was as regards only that Doldoli, my lord. Since it's-
Doldoli, we are not concerned, my lord. I am not concerned with Doldoli, my lord.
My lord,
It's only that land.
Well-
If you say that, because you see, if you compel me to write, then I'll have to record it. Then once it is lapsed, no right will accrue.
my lord.
It will give you more dangerous repercussion. You want me to record it?
No, my lord. That was a different context.
No.
I take my seat.
No. Because this is only a notice of motion I am issuing, but it's a prayer of stay, therefore I am compelled to
Well-
write. Otherwise, I would
Well-
not have written so much. Next, in reply, the learned counsel for the petitioner has referred to the case of Hills Syndicate versus North Kachar Hills Autonomous Council and others, within bracket 2000, bracket goes to GLR 356, to project that the Karbi Anglong Autonomous Council do not have a right to declare any land as a forest land.
My lord. Not as a reserve forest, proposed reserve forest.
As a proposed reserve forest. Next para. If you notice a motion returnable in. It's eviction drive, you can make it in 3 weeks. In 3 weeks. Because the extra copies of the resolution will serve on the state and departmental council in course of the day. Next, heard both sides on the prayer for interim relief. The factual aspects have already been narrated herein before. Next, insofar as the prayer for interim stay is concerned, this court by order dated 18/9/2018, passed in WBC 2545 of 2018. It already protected the interest of the petitioner by providing that the respondents in the Karbi Anglong Autonomous Council shall not indulge in evicting the petitioner from his declared patta land without following due process of law. And it was also provided that there shall not be any bar on part of the Karbi Anglong Autonomous Council authorities to evict the petitioner from any land, other than his patta land, which may be under his occupation, be it land within a forest area or otherwise, and in doing so, the authorities were directed to follow the due process of law. Full stop. Next paragraph, the categorical statement of the learned standing counsel for the Karbi Autonomous Council is that the petitioner would not be evicted from any patta land, except and that the eviction drive shall only continue in respect of Doldori Reserve Forest, DOLI Reserve Forest.
And from government lands.
And from government land. Next paragraph. In this regard, the court finds that court is intent to observe that the notification dated 14/10/1969 was to invite claims and objections with regard to declaring of the land containing Schedule J2 to be a reserve forest, sorry, district council reserve forest, and therefore the said notification is only for a proposed reserve forest. First of all, the description of boundary sorry, the schedule of the boundary is as follows. You can scan and put in this part. Don't have to type it. Scan and make it a part of the order. Just here. Full stop. Accordingly, it is provided that insofar as the proposed reserve forest is concerned, if a preliminary and a final notification to declare the land covered by the said schedule has been issued, the said land would be squarely covered by reserve by district council reserve forest, and therefore notwithstanding the ownership with regard to this said land, a right would accrue to the Karbi Autonomous Council to evict persons residing therein. Evict the petitioner, if any part of his patta land is covered by the said reserve forest, declared forest, declared autonomous, district council reserve forest, but not otherwise. Full stop. Next paragraph. In the order dated 18/9/2018, passed in WBC 2545 of 2018, this court had provided in paragraph 14 thereof that the respondents, the Karbi Autonomous Council, shall undertake a survey and identify the patta land of the petitioner and demarcate it, and upon doing so, shall not prevent the petitioner from undertaking any construction over his patta land upon such demarcation being made. Full stop.
There are 13 also. That's the moment.
No, that is eviction that you are not doing. But this is what we want. We want him to be protected from that pata land. Stop. The said exercise has to be carried out by the Caribbean Autonomous Council and brought to its logical conclusion to ensure that the petitioner is not threatened of being evicted without due process of law on his pata land. Full stop. The who's to carry out this exercise?
Periodic Patalan, it will be by the revenue department.
Just see the respondents. Which of the respondents? Respondent number 3.
Lordship, as he has not met the secretary, he has met the deputy secretary. Respondent number 3.
3. Okay.
But Lordship, just observe that, my lord, petitioner shall cooperate with the my lord that pass only.
Okay.
And he will, my lord, not prevent to visit the site verification.
Okay. The on a certified copy of this order being produced before the respondent number 3, the Deputy Secretary, Department of Revenue, KAC, shall ensure that within a time-bound period of 1 month, within 1 month, 1 month, the pata land of the petitioner shall be demarcated from the government and forest land, be it the state reserve forest or a district council reserve forest. Full stop. Insofar as the district council reserve forest and the state reserve forest is concerned, the respondents, the dependency of this registration shall not be a bar for the respondent authorities. So in the first part, you write what Mr. Sudhir said, that in the exercise to be carried out by the revenue officials of the Caribbean Autonomous Council for demarcation of the land, the petitioner shall extend all cooperation by providing with the authorities with a copy of his pata and other land documents, so as to enable the
Specific period, my lord. In a specific period, my lord. Within 10 days, whatever time they may want.
within by providing this also within a period of 7 days. And on receipt of certificate copy along with the documents, the 30 days, the exercise to be carried out within 30 days. Insofar as the forest, the district council forest land and the state forest land is concerned, the dependency of this reference shall not be a bar for the respondent authorities to carry out the eviction drive. However, in doing so, the authorities shall ensure that no part of the pata land or the petitioner is usurped in the name of eviction drive. Full stop. The area within which the eviction drive is carried out shall be documented and copy thereof be produced before the court through the Learned Standing Council. Next para. Issue was raised by the Learned Standing Council for the Learned Council for the petitioner, to the effect that the Caribbean Autonomous Council would not have a right to declare any land as a forest land. First of all, although finding of fact is not being returned, but the privacy view of this court is that as the forest is a transfer subject to the Carbon Autonomous Council under Schedule 6, under 6th schedule of the Constitution of India,
Have the right to, my lord,
the under the
paragraph 3B,
3,
3(1)B of the sixth schedule
as a para 3(1)B of the 6th schedule,
empowers to make law on the
comma,
management of
which-
any forest not
which
being a reserve forest.
which empowers the
To make law
Carbon Autonomous Council to make laws
on the management of any forest
on the management of any forest
not being a reserve forest.
not being a reserve forest, and the same being prima facie found from a conjoint reading of section 3 and section 1 within bracket 2 of the Meeker Hills within bracket Forest bracket Close Act 1957. Comma, the now, perhaps it appears that the district council would have a right to district council reserve forest areas.
Let that issue be kept open, my lord.
I'm kept open. I'm just saying prima facie view.
My lord.
We have raised it. I have to
Record it, yeah, I
adjudicate.
understand.
Otherwise, you will see that my issue was not
No, my lord.
adjudicated.
Well, let this two regulations, what they're referring, like colleagues are referring,
No, it is
let it be
given.
provided to us, my lord.
I'll
I'll download it from the my lord website and
My lord,
give
in
it-
the website, I have checked it out.
he'll get it in local X, my lord.
He says that he'll give it. Well, from where he gives his responsibility.
My lord.
Correct.
Always, my lord.
More than I've been knowing you, I have known Mr. Sudhir for a longer period.
My lord.
Correct. That's what- when he says that he'll give it, I have full faith on him.
My lord. Oblige, your lordship.
Next date will be after 3 weeks. Give me a date. Mr. Sutia,
Just before vacation, my lord, once.
give a date. When, by when? 3 weeks, I have said. Give a date.
June, no? I just said, let it be on 28th, my lord.
It's for them to do that exercise. Yes,
28.
And wait, take one second. Please take one second.
28 is just before vacation. No, not on that, those days.
Then after vacation, my
After
lord.
vacation.
It goes after vacation.
After vacation, my lord.
19/7.
97 months.
Okay, just tell them that no eviction from Patavan. Okay,
Oblige, your lordship.
List item number 1, bail hearing. Please take this on under 438, my lord. This is
And in this
second
case,
round.
interim granted on 10/5, directed me to take the up to the instructions, status report of the matter. But they have sent the case diary again, matlab, up to the city, matlab. This person matlab appeared on after the court order on 20th of May, matlab. 20th of May. This statement recorded, but subsequently it was also directed to appear in every 10 days before the IO. But that subsequent report I have not found. Today I have called to the matlab, OC of matlab, that IO was in training, matlab. He is not in station. Matlab.
okay.
So because of that virus, matlab, but CD we have received on 3rd of June. Yes, after that news. So he has appeared, his statement recorded,
Just show me that statement.
my lord. His statement. He said that he do not, it is also. He don't have the license to have cattle in within Assam. His license up to West
He does
Bengal.
not have. Okay, we'll make the bail absolute and we give direction for him to appear.
My lord, yes, appear, my lord. Next.
Have Mr. U.J. Saikar and counsel for the petitioner and Mr. K.K. Parashal and the APP for the state. Next para. Apprehending arrest in connection with so-and-so. Application number 438 CRPC. Next para. The pursuant to order dated 10/5/2023, the learned APP has produced the case diary and has opposed the prayer for bail on the ground that the petitioner does not have sufficient documents to transport and or otherwise deal in cattle in the state of Assam. First off, it is submitted that the person to interim bail granted on 10/5/2023, the petitioner had appeared before the IO on 20/5/2023, and his statement has been recorded. It is submitted that the petitioner was directed to appear before the IO on 22/5/2023. But in the meanwhile, the IO is on training. First off, having noted that the petitioner has appeared before the learned IO after interim PRS bail was granted by order dated 10/5/2023, the court is inclined to make this said interim bail absolute. First of all, on the following terms. On the same terms, full stop. In addition to previous terms contained in order dated 10/5/2023, it is provided that the petitioner shall appear before the IO every 15 days, to his personal appearance dispensed without charge sheet is submitted, whichever is earlier. It is also provided that in the event the petitioner is found to be transporting or dealing with cattle in any manner without lawful documents, it would be open to the IO to approach the jurisdictional court and apply for cancellation of bail. Just at the end of the petitioner does not appear before the IO is directed. For these two reasons, that here we will apply for cancellation of bail. Which is there is be sent back. Application disposed of. Yes. Okay. You have splint in your arms.
Lordship.
Yes. You have splint in your arms. What have
Yes,
you?
Lordship, fracture, Lordship.
Okay. Non-appearance on call for the applicant. However, Mr.
PP meeting.
P.P. Mehdi, runner counsel for the respondent opposite party is present. Next para. It is observed from the order dated 27/4/2023 and 26/5/2023, that the learned counsel for the applicant who's the petitioner in the connected election petition, has withdrawn from the case. By sending a notice to the applicant. Post- Next slide, we see that the applicant was not represented when the matter was called on 26/5/2023. As well as today, post according to the court. Is of the opinion that the petitioner is not, the applicant is not interested to pursue this interlocutory application, and therefore this interlocutory application stands dismissed for non-prosecution. Now this election petition will come up.
Lordship.
Uh, The election petition, right? Uh,
Lordship, we have filed one IA 284 of 2023 for the restoration of IA 1272 of 2021. Recalling order dated 9/2/2021.
Which IA?
IA 284 of 2023.
284.
284.
Ah, yes, it is there. Oh, no, no. Oh, no, this is wrong then. I thought here he was the petitioner. This is your petition.
This is our petition, Lordship.
Oh, it's not dismissed for the one then. Okay, you want to do this matter now?
Lordship, Lordship will pass the order, Lordship.
No, because this is for restoration. I'll have to hear you.
Lordship. Not today, Lordship.
When?
After 2 weeks, Lordship.
Don't read this. That will remain, but will come in a different paragraph. Mr. P.P. Mehdi, Learned Counsel for the applicant is present. None appears on call for the opposite party, whose counsel had withdrawn from the case as per order dated 27/4/2023, read with order dated 26/5/2023. So therefore, the opposite party remains unrepresented. Next paragraph. The learned counsel for the applicant submits that this interlocutory application be heard accordingly as straight for list after 2 weeks.
Lordship.
Earlier order will not be there. Okay. There will be no order in IA, sorry, election petition. Okay.
Deeply obliged, Lordship.
How's Mr. Pathak?
Lordship.
How is his health, Mr. Pathak, senior counsel?
Yes. Now it is okay, Lordship.
Okay. Just come back to Guwahati?
He's in Delhi.
He's still in Delhi. Okay.
Deeply obliged, Lordship.
Stay matters, item number 3.
My pleasure, Lordship. My Lord, in this case, I pray for the respondent, my Lord.
Yes.
I pray for further time of 3 weeks, my Lord. I am yet to receive instruction, my Lord, for filing affidavit in opposition.
Okay. I don't see both sides are duly represented. On the prayer made by the Mr. Secretary Lawrence, counsel for respondents, further 3 weeks time is granted to file affidavit in opposition to the matter. So the interim order passed earlier stands. Oh, it's under further
Yes.
orders. It is further orders. Okay, not required. Okay.
Or
Yes, my lord, the pleading is completed in this case, my lord. Pleading is the affidavit and the
Yes.
reply we have filed.
You want to do it today or some
Fix
other
it,
day?
Any date, my lord,
When?
whichever is convenient.
No,
There are short points, very short point. If
you
your
just say when
lordship
you want.
want to hear it, your lordship can hear it. It's up to the railway if they're ready with this case, my lord.
Yes. Both of you agree to a date if you do not do it
Yes,
today.
Lordship, immediately after vacation, Lordship.
You consult Mr. Das, when do you want to give a date? We'll take it on that day.
After reopening is like
Suggest a date, we'll give it on that day.
July, some. Immediate.
Can it be on 25th?
20th of July. 20th of July. 25th
25th?
of July
25th.
or July.
Heard Mr. D. Das, Learned Senior Counsel, assisted by
S. Sharma.
Mr. Sharma, Counsel for the petitioner, and Ms. B. Sharma, and CC appearing for the respondents. So, it is submitted at the bar that the case is ready as seeker service and readings have been exchanged. So, in view of the nature of dispute raised in this writ petition, this writ petition stands admitted for hearing by issuing rule returnable forthwith without requiring the petitioner to take fresh steps. Next, as agreed to by both sides, this is the matter for hearing on 25/7/2023. So that's what the point involved. Just
The point is involved is here, my lord. They have resort to terminate my contract on the 24th. I was running a train. Their train during the 2018. After 2018, there was a COVID, my lord. So there was suspension of running of this train. 2021, again, they have written to us that you restart the operation of the one. 22nd/7/2021, we have written to them. They said very difficult to get a customer because that time also COVID was going. Give some time to us. Now there is a provision that if you can't run, that there is a provision for surrendering it. So accordingly, we have also written that they will not be able. We will surrender as per the provision. This appeal was not considered, and ultimately we said if that be the case, we'll start the operational work. Now, my lord, what they have done, they have not given any reply. Suddenly on 17/3/2022, without giving any notice, my lord, they have terminated our contract. That's the case. And
Okay.
they have resorted to 20.4, which they should have been under 21.2, giving a notice to us, which they have not given in the case.
okay.
There is some protection which has been given by this court, man.
But in this page 118,
Yes,
para 12, they have given an explanation.
118, yes. No. Affidavit.
Para 12, Lordship.
They said that sufficient time was granted, but the operation comes under zonal railway,
Yes.
and therefore appeal was forwarded to zonal railway quarter.
What we said, my lord, the period which we couldn't operate due to COVID, that period should be excluded. That period should be excluded. Your lordship, no, all the period, COVID time, there was all, the benefit was given. We could not run the train. COVID, there was lockdown totally. 2020. Now, our whole case is that you cannot resort my termination at 20.4. 20.4, my lord will kindly see at page 37. 39.
Cancelled.
Page
Cancelled.
39.
No, cancelled.
They have what they 29, 20. Kindly see for a moment, my lord, 39.
Page 39.
39. For my read petition. (20.4) If the leaseholder, after commencement of the loading, fails to operate the contract continuously for 10 days without giving any notice, his contract will terminate as security deposit forfeited. So they have resorted to 20.4. And my case, that when you terminate, because this is only, my lord, we fail to operate continuously for 10 days. Here, my lord, lot of repentation was given. They have not resorted any reply to my repentation. After 6 months, my lord, what they have done at page, my termination,
Yeah, according to you, which clause will apply?
my according to me, my lord, your lordship will kindly see at page 93. According to me, 93 will apply. They have terminated my contract 93. Kindly see 21.0, right to terminate lease contract 21.1. Railways shall have the right to terminate the contract agreement for any reason whatsoever after serving 1 month notice to a leaseholder. However, railways shall reserve the right to terminate contract as a punitive measure without any notice at any time in case of breach of agreement or serious violation any of the stipulation of policy, railway rule by the leaseholder of, or in a case of operational agreement. However, such instantaneous termination of contract by railway administration should be followed by a written intimation of breach of within 3 working days of termination. So either of these two particular provision, these two particular areas they have not followed. You can terminate my contract without, my lord, 1 month notice has to be given. Secondly, my lord, as a punitive measure also without notice, but 3 days time you have to give. Now my termination, kindly see at page.
Where is your contract?
I'm sorry.
Where is your contract?
My contract, my lord, is at page 79, my lord. 77 it starts. 77 it starts. 28th of December 2018. This is a period for 5 years.
No, then Mr. Das, I'm just asking you for a different reason.
Yeah.
You see, you come back to page 93.
93.
93 is right to terminate the lease contract.
93, man.
Yes,
Yes.
the page you are showing.
Yes.
Here, the first condition is when the train is converted into LHB rake and suitable VP that can be attached to a LHB rake is not available, the following clause will apply to a contract. But here in your contract at page 77,
Yes.
it is for a parcel space in a parcel van.
Yes.
So it does not, this is not a case which is of LHB rake. Apparently, this train is not LHB rake.
No.
So 21, you have to, on facts, we'll have to satisfy on the next date. I'm just giving you an.
Yes, yes.
But we'll hear you on the next date, but
Yes, yes.
I'm just trying to have an overview of
Yes,
the.
yes.
So if it is not an LHB, then perhaps you may not get the benefit of 21.0 or other clauses.
In
On
our,
the next date, you will.
Yes.
I'm just, we'll hear it on another day, but I'm just trying to understand the overview so
Yeah.
that, because when the agreements are so big.
Yes.
in our affidavit also, we have annex 1 instruction and there
Okay.
also it is written.
Now I've just understand the overview because it is very difficult to read.
Yes,
That's so much of volume.
Obliged.
The entry order will continue.
Item 5,
Entry order will continue.
entry order past case transaction extended to the next date of
Yes.
listing.
Yes.
May I please your lordship? Now, on last occasion, respondent prayed for some time to file it.
Yes.
The private respondents are also there, but we have not received instruction launch.
May I please your lordship?
Yeah, just a moment. Where is this miss case 268? Where is that?
Annexure 5, my lord, notice.
Page, give me the
Page
page.
33.
Page 30,
33.
33.
Yes.
No, please.
Just a moment. This is what has been challenged.
This
This
is challenge, my lord. I have made prayer. This case 268, 21.
Yes,
Lordship, I'm appearing on behalf of Mr. Arvi Fukan. Lordship would grant 3 weeks time to file affidavit in opposition.
how much cost will you pay? How much cost will you pay?
I have not received any instructions regarding.
No, if you, because you see, this is a notice issued in 22. We are still in the process of getting instructions.
Petition of ancestral property purchased in the year 1989. Since then, they are in possession and paying government land revenue. Suddenly, my lord, respondent number 3, high-handedly disturbing the petitioners by issuing that notice. And on the other hand, he asked the petitioner to make compromise with the private respondent.
Uh, This. Just show me who's the seller of your land,
Go ahead. My lord.
the sale deed at page 17.
Yes,
You are the beneficiary of the sale deed, right?
yes.
Now come to page 29 and show me who are your vendors.
Page 39.
Page 29, come to page 29 and show me your vendors. Page 17 and 29. Show me who are your vendors.
Page 18.
17.
17, yes.
17 is the sale deed. Page
Yes.
29 is your Jamabandi. You show me who are your vendors from Jamabandi.
I have annex as annex of 3, my lord. Page 29, not 39, page 29.
I can read that much. That's what I'm asking you. Show me the vendors. Who are the vendors?
Yes.
Page 17 is your vendors. Who are your vendors? From page 29, show me that.
Eviction Mahajan. Monkidor. Podmoram.
Oh, name I can understand. You show me from that page entry at page 29. Who are your vendors? Which serial number are your vendors?
Yes, my lord. It is specifically mentioned on Devanchandra Mahajan,
Serial number?
1. Monkidor Das.
Serial number 1 is Lakhiram Das. I'm just not asking you this for fun.
No, my lord, sold it.
If you have not understood my question, please ask me 10
Yes.
times.
Yes, yeah.
You got the Jamamandi. Now tell me who are your vendors from Jamamandi.
Lokhiram Das, son of my lord. Pumud Das had sold out the property, son of Lokhiram Das, who was the Lokhiram Das. His name was erased in the Jamamandi after selling. Seller number 8, my lord. Pumud Das,
Seller
Son of-
number 8 is Pramod Das,
son of Lokhiram Das.
son of
Original-
Lakhiram Das.
Yes.
Yes.
And
No, Lakhiram Das. Where is Lakhiram Das?
in the sale deed, my lord, it is mentioned.
No. In the Jamamandi serial number?
1,
Serial number 1.
yes.
Now, what is his, what is his, what you call, what is his land holding?
176, 177. Yes. And I have annexed the relevant portion of type copy, but in the Assamese person, my
I'm reading Assamese only.
Yes,
Sir,
yes.
I'm showing you on the page
yes.
929.
One,
I'm not showing you some other page.
Yes, my lord. And Punoram Das.
So
Motiram-
his land is not determined. Correct.
Yes, my lord.
Now, who's the second? Go by serial number 1, Devanchandra Mahajan. Who is he?
Soniram, son of Soniram, Santiram.
Show me the entry at page Jamamandi, page 29. Just tell me if serial number 1, 2, 3, 4. That is the entire exercise you have to do.
Yes, my lord. Number 2, Bonkiram Das, his name was also
No, go
mentioned.
serially. You see, otherwise I'll forget what I'm reading. No, executed by number 1, Devanchandra Mahajan.
Yes.
So
Devendra
where is
Mahajan.
his name in the Jamamandi?
His father name was mentioned in
So then the proceeding is right. You are saying that he should go to civil court. He can't go to civil court.
Yes.
If you can't show from the Javabandi that he had a determined right.
Actually, my lord, circle officer is not the appropriate authority to cancel that earlier mutation order, my lord. I have mentioned that.
Okay, from which provision of the land revenue regulation you are saying so?
It's a- The object of mutation. Revenue court is not entitled to decide the title in respect of land property, which is subject matter of. the
Okay,
civil.
according to you, prayer for cancellation of mutation is determination of title.
No, my lord.
Then
The object of mutation is only to facilitate
No,
the
no.
payment of land revenue.
I'm not on the object.
Yes.
You are saying that the circle officer did not have the authority to do so. I'm just asking you which provision of land revenue regulation.
No, it is showing cancellation of mutation, which is mentioning section 53A.
53A.
Yes. Cancellation of mutation. Then revenue regulation has given a right to a person to cancel a mutation obtained illegally, but that does not mean that civil court shall have no jurisdiction to give declaration.
So that is different matter.
My lord, after issuing that notice by respondent number 3, my lord, what happened, my lord? Petitioner appeared before the respondent number 3. Even my lord, copies of the case was not provided to the petitioner to defend their case. On the other hand, my lord, the respondent number 3 asked the petitioner to enter into compromise with the private respondent, my lord. That's why the petitioner, having no option, my lord, only was compelled to approach before this honorable court.
No. You have to go back there. In your sale lead, you not even said how much share one has. That's why I was reading your.
Well, I will file additional affidavit if this honorable court.
No. After I ask a question, then you will file additional affidavit for every question. Then I always ask questions. So this will be never-ending process till I superannuate.
My lord, only after.
No, I understand, but every time it comes to my court, I'll ask a question. You will file an additional affidavit for that.
It was registered and ancestor of the petitioner parcel. That
You see, you are Mr. Kalita, right?
Yes, madam.
Mr. Kalita, this sale deed, can you file an affidavit and improve the contents of this
No,
sale deed?
madam.
Then,
I'll take instruction one.
no, you go back there. We can't stay for an instructions. There will be never an instruction which can, what do you call, which will improve your sale deed.
Sale deed was registered, my lord.
It's okay. That's why I'm asking you. You see, that's why I'm spending some time reading your sale deed in Assamese, reading your Jamabandi in Assamese, and then trying to find out.
Actually, my lord, it is computerized Jamabandi copy, my lord.
I understand.
And if this honorable court allow me
Is
to, I will put
is it your case that Devin Chandra Mahajan was the only son of so and so, and he had a determinative right over the share he had sold? Is it your
Yeah.
case? No. So you only have a right of partition. If you have purchased a land of 6 bigha out of the common land,
Yes.
correct? The only right you have is for seeking partition, nothing more.
But if this honorable court allow me to produce draft sheet copy, my lord.
You want me to rely on a draft sheeta?
Yes.
Is draft sheeta a primary evidence?
No.
Then
Since this is computerized, my lord.
Chitta is only a draft. And it is always a secondary evidence. Chitta is never a primary evidence.
Yes.
So when there is a better evidence available by way of a Jamabandi, can I rely on a Chitta? All evidence before the court must be direct. What is it, section 61 or 63? Evidence Act? Evidence must be direct. So Chitta is not a primary evidence, it is only a draft.
My lord, I will take instruction if this.
No, you go back. We can't withhold this matter.
Yes,
It is
my lord,
unnecessary
please
wastage of time.
he, my lord, may kindly be directed not to disturb the petitioners, my lord.
No, they can't, he can't do anything. As a person who is handling the matter of what you call cancellation,
Yes,
the prayer for cancellation, he can't do anything more. He can merely cancel your mutation. But he can't take away your vested right.
after so many years, my lord, the respondent only came to know in the year
No, you-
2022, my lord, they were never in possession, my lord.
It's
And-
okay. Mr.
Well,
Kalita, this argument will not take you anywhere. Because when it's a joint pata,
Yes, my lord.
a possession of one is a constructive possession for all. You can't say that in a joint pata, nobody is holding position just because he is physically not there.
But we are in possession since 1989, my lord.
It's okay. That is a defense you'll have to take.
Yes, my lord, if they are,
But once your determinative right is not there in the sale deed, it's just not there. You can't improve it. Heard Mr. K. Kalita, counsel for the petitioner, petitioners, and Mr. Miss. I forget your name again.
MSN Bordelot.
N. Bordelot.
One.
For respondent number one.
For 2 and 3.
Mr. N. Goswami, government advocate appearing for respondent number 2 and 3. And Mr. Your name? I.
Yeah.
Bhoyar and counsel for respondent numbers
4 to 13.
4 to 13. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the proceedings of Miss Case 268/2021-2022 pending before the Learned Circle Officer, Palashbari Revenue Circle, and has prayed for quashing the said application as well as notice dated 31/3/2022. Next paragraph. The case of the petitioner, in brief, is that their predecessor in interest, namely number one, Umakanta Mali, within bracket, father of petitioner number 1 and 2, bracket closed, comma, Ramakanta Das, within bracket, father of petitioner number 5 and 6, and Naveen Chandra Medhi, within bracket, father of petitioner number 3 and 4. Comma, all sons of late Gunaram Mali, Junaram Mali, comma, during their lifetime, had purchased a plot of land measuring 6 bigha, 4 katha, 17 lecha, covered by dag number 176 and 177 of KP Pata number 580 of village Palli PALLI, comma, Chayani Moja, CHAYANI, Moja under Palashbari Revenue Circle, while registered sale lead number 2854 dated 24/7/1989 from the Mr. Kalita,
yes,
any of your vendor is the original Patadar? I don't think so, because that's what I am wanting to. Is any of the vendors Patadar?
Bonkiram Das, my lord, it is mentioned. my lord.
Number 2. Where is this?
Number two, his name is deleted. Bonkiram Das, in his Omani, his name is mentioned.
Serial number 4.
Four, yes.
Okay. From
One more submission, my lord, if this one I will go. Well, petitioner's name were mutated after death of their fathers, my lord.
Whose name?
Petitioner's name, my lord. And their names were mutated only after field revocation, my lord. That is reflected in the Zomamundi copy. Kindly peruse, my lord.
You
Page
see,
28.
you see, I'll tell you. If I record things, it will be bad to work for you. The reason is very simple. You see, that's the reason I'm making an inquiry. I'm asking you to show the names for a different reason. Number one, in the sale deed, it is not mentioned that, say, let us say serial number 4 of this Jamavandi, Bankiram Das. Bankiram Das share in this land was so and so, which is entirely sold. That is not you are saying in the sale deed. In the sale deed, the breakup of the land of the vendors are not given. There are as many as 8 vendors,
Yes,
right?
yes.
In your sale deed in Assamese, you have not stated what is the share of each of the patadars in the said land. Correct? Say vendors, not patadar, vendors is how much you have not said that. Now, the second part is that in the sale deed, if their respective shares are not mentioned, number one, we don't know as to whether on death of, say, serial number 1, Lakhiram Das, when he died, we don't know. Which of his sons were the legatees, that we don't know. Correct. In the sale deed, you have not mentioned that X is the son of
Yes.
Lakhiram Das, who died without leaving any heir. Therefore, we don't even know if on death of Lakhiram Das, the vendor, supposing, let us say for an example, it may be wrong, Devin Chandra Mahajan number 1 seller is his son. I'm just saying for an example, it may not be right. He is the vendor, that he does not have any other siblings or his mother as a legatee to Lakhiram Das is not known. Correct.
Correct. But my lord, the respondent, private respondents who are claiming that this landed property is their land, but they did fail to give proof, my lord, before the respondent also.
No. The proceeding is stayed. The proof will come only when he takes up this matter. But if if you are besieging me to write something, then it will go heavily against you. I have to make observations which will be against you. That's what I'm not doing it.
Yes, my lord, but this petitioners prefer this petition only after being harassed by the respondent.
No,
party.
it's okay.
They
But,
who
but
asked
you
the
tell me,
petitioner-
you see, I'm not asking you something which is beyond beyond the purview of a sale within the meaning of Section 54 of the Transfer of Property Act. You see, who can be a seller? He can be an ostensible owner. He can be an owner within the meaning of 41 to what you call 43, 44. So sale by an owner, sell by an ostensibly owner, sell by what you call representative capacity. So therefore, in the sale deed, it must, if it is not written, that the vendor derives title from whom? Say for Devin Chandra Mahajan. Is his name in the Jamavandi? It is not. Therefore, he is selling on behalf of someone. The vendor number 1, Devin Chandra Mahajan.
Yes, yes.
His name is not there in the Jamavandi.
But when I have also annexed the mutation order, annexed to kindly page 24, my lord.
Mutation order is something else. Mutation doesn't desire a title.
Yes, ma'am. That is-
Section 50 is mutation. Mutation, there are judgments of this court which say mutation doesn't deny title, it only creates a right. Now, you see, for example, you just show me one thing. I'm only on serial number 1, Devin Chandra Mahajan. His name is not there in the Jamavandi. How far his sale would be valid? Because you see, you don't even say in your sale deed that Devin Chandra Mahajan, his father's name is Saniram Mahajan. Saniram Mahajan had no other legal heir except for him. Saniram Mahajan name again is not there
Yes, yes.
in the Jamavandi.
Yes.
So definitely you don't want the High Court to record a finding of fact. It will go to the root of your sale deed. I'm not doing it. Correct.
Correct.
That is why I'm trying to ask you the questions as to the vendors correlated to the Jamabandi. If the definite shares are not there, then you only have a right to partition.
The private respondent did not mention anything, my lord, before the respondent number 3, my lord, who issued notice, and immediately after receiving the notice, the petitioners appeared before him. And what, instead of
Mr.
punishing-
Kalita, you have to show me from the land and revenue regulation
Yes,
that at the time of issuance of notice, it is his duty to
Yes, my lord,
to satisfy
yes.
himself
yes,
that the objectors have a valid right title interest, and then he will do that.
yes, my lord.
If he has received an application, he has issued your notice, you go and
Appeared.
you appear and give your reply.
Petitioner appeared before the respondent number 3, my lord. What the respondent number 3 finally asked the petitioner.
No, it's
to
okay,
enter
you
into
see,
compromise, my lord.
no, it's
Then
okay.
he would-
You see, what is wrong in that? If somebody, if a circle officer says that you try to compromise, is it so inherently wrong that the High Court will interfere? Even we say at times that you go and appear before the mediation center, try to have the matter solved between yourselves.
Yes.
So, Section 89 we invoke.
my lord, what-
Is it so bad that the High Court will interfere in the jurisdiction?
we've had this petitioner seeking protection, my lord.
Now you see what happens. Supposing I, as a court, when I'm looking at a matter,
Yes.
I see it, and then in one case I just make an observation. Why don't you settle it?
Yes, my lord, that is.
If I make that
It
statement,
happens, my lord.
would it mean that it is inherently bad that the observation of the court has to be challenged by saying that why the court made an endeavor to make that
Petitioner was
statement?
not given any opportunity to give reply.
No, we'll give you an
Time of
opportunity.
punishing- Yes, my lord.
We'll give you an opportunity.
Yes,
But you see, I have had some experience in trial court,
yes,
correct? Some amount of experience. In at least in Guwahati, in the Deputy Commissioner's Court, in case of mutation, in case of an application for cancellation of mutation, I have not seen a single lawyer who will enclose any document in support of his petition. That is not to my experience, but my experience is very limited. But whatever experience I have got, I have never found that any petition carries with it a documents annexed to show his primacy title. It is only at the time of what you call supplementing it on appearance, then they give it. You file an application before the circle officer will permit them. Circle officer will permit that. Next paragraph, the learned counsel for the petitioner has submitted that the issuance of notice of miscase 268 of 2021-2022 is expressly arbitrary and illegal. So it is submitted that on appearance of the petitioner, the Circle Officer Palasbury, within bracket respondent number 3, did not provide with to the petitioner any document on which the private respondents relied upon. So it is submitted that in course of on appearance, the respondent number 3 had asked the petitioner to settle the matter with the private respondents. So accordingly, it is submitted that the coercive, the petitioners apprehend that the respondent number 3 would arbitrarily decide the matter without giving a reasonable opportunity to the petitioner to represent their case. So hence this writ petition. Next paragraph. The learned state and departmental counsel have submitted that they have not received instructions. Post as it is counsel for the private respondent numbers 9, what do you call it? 4 to 13. And therefore, all of them pray for some more time to obtain instructions in the matter. Next paragraph. Having regard to the nature of proceedings in form of miss case number 268 of 2021-2022 is concerned, the application is merely filed for cancellation of mutation. Full stop. The jurisdiction to register and adjudicate an application for cancellation of mutation is vested with the land revenue authorities, which includes the circle officer. Under the scheme of the Assam Land and Revenue Regulation, 1886, as against any order that would be passed by the by the settlement officer, oblique assistant settlement officer, subdivisional officer, assistant commissioner or assistant extra assistant commissioner, and deputy commissioner of the settlement officer or survey officer lies to the authorities prescribed under the provisions of section 147 of the Assam Land and Revenue Regulation.
1886.
Stop. When a circle officer takes up the hearing on an application for cancellation of mutation, he would be exercising jurisdiction of Mr. Goswami, assistant settlement officer. He is the circle officer is what? He is a settlement officer.
Extra assistant commissioner.
Huh?
Extra assistant commissioner.
Circle officer is extra assistant commissioner. Just try to find out.
Gotcha.
You give me that correct name.
Gotcha.
Circle officer is equivalent to
Gotcha.
which office? Because he can't take up the matter as circle officer. You come to 147
Gotcha, right.
and revenue matters, he exercises jurisdiction subdivisional officer or settlement officer.
Gotcha.
Just like that. So and so. Next paragraph. Therefore, if the petitioner is agreed by any of the orders which is passed by the authorities described in section 147 of the Assam Land and Revenue Regulation, 1886, provisions for appeal has been provided for. Full stop. Next paragraph. The learned counsel for the petitioner expresses apprehension that the circle officer with the respondent number 3 may also evict the petitioner by without due process of law. Full stop. In the considered opinion of the court, comma, without an adjudication, comma, the land revenue authorities would not have power to evict the petitioners, and only if the matter is decided finally, it will depend on the jurisdiction which is sought to be invoked for evicting, if there be any. First of all, as the issue of eviction is not the subject matter of this writ petition, no final opinion is expressed thereon. Next paragraph. Insofar as the grievance of the petitioner that on appearance, the respondent number 3 did not provide him with any documents to take an effective defense, the court finds merit in the said submission. Hence, it is provided that if the petitioner makes an application before the respondent number 3 for providing the copies on which the private respondents hearing are relying upon, it would be incumbent on the respondent number 3 to provide the petitioner with the relevant documents and give time to the petitioners to take an effective defense. Therefore, it is provided that in the event the petitioners approach the respondent number 3 with a petition to provide him with documents on which the private respondents are relying upon, the respondent number 3 shall entertain this petition by numbering it and pass appropriate orders thereon. In the event the private respondents have not filed any documents in support of their application for cancellation of mutation, the circle officer within bracket respondent number 3 shall record the same in the order sheet and allow the petitioner to have copies of the said order. Next paragraph. Only on the ground that alternative efficacious remedy is available to the petitioner, this court has not entered into the merit of the respective claims of the petitioners and the private respondents, which is left open to be decided by the respondent number 3 strictly in accordance with the provisions of Assam Land and Revenue Regulation, 1886, and rules framed thereunder. Next, accordingly, without rendering any opinion on the respective claims of the petitioners and the private respondents, the court is inclined to delegate the petitioners to appear before the circle officer, Palashbari Revenue Circle, within bracket respondent number 3, on when, Mr. Kalita?
The last part of July, my lord.
Okay. On 21/7. Yes.
My lord.
21/7/2023, without any further notice of appearance, the petitions and private respondents will appear with petitions. And the petitioners are permitted to make an application before the respondent number 3 to provide him with documents on which the private respondents are relying upon, as already indicated above, and give reasonable opportunity to the petitioners to take their defense. With the opposite observations, this petition stands closed. You're not expressing any merit, any opinion on merit.
Obliged.
I'll take a break and come back.
Your Honor, Lordship, I'm appearing, Mr. B.D. Rekha's name has been shown for the respondent. Lordship, they are not engaged in this matter anymore.
Okay. But there's no application to strike off your name. So therefore, your name will appear as defaulters.
Lordship will make the application.
Okay, since you're not there, you're excused.
Obliged, Lordship.
Where is the order of? Where is the order of the what do you call this? Consumer grievance forum, grievance forum, where is that?
That Lordship find is page 25,
25.
25, agenda 1. That part only, so far as the case is concerned, agenda one.
Okay.
Let it be in the list, Milord. Okay.
Actually, I'll be more specific in the query.
Lordship?
I'll be more specific in the query. You just
Yes, yes.
note that. Now, this page 25, which you have shown.
Okay.
This 3% additional charge to compensate the losses.
Right.
The power to which is not referred to this, about extra billing. Got it?
I get it.
Second is that at page 122 is the appellate order. Now here, nothing was produced, I think, before them to show that this 1,200 kilowatt, if they are consuming,
Right.
they'll have to take power from 33 kilowatt line.
I got it very well.
Right, because you are on the page 129.
Right.
It is a reference that time and again the respondents have cited 2.2 of the ERC code,
Right.
under which by exercising discretionary power, the distribution licensee of debit 3%.
Right.
Correct. You got it?
Lordship.
So that is the point.
Otherwise, Lordship.
You don't say that it is as per the tariff. You say that it's a discretionary point we are taking to levy. That is your case before the appellate authority.
Falls back on tariff.
Huh?
It falls back on tariff.
No, it's not. It's not. That's why I said the tariff will be something which is
I'll get
prescribed.
back with instructions from that because I have.
If it is not there, you use your cases before the appellate authority that you have exercised discretionary power to do it. That's what I have shown you at page 159. So it's not a power exercise under the tariff.
Let it be on.
Therefore, it's not a question which is relatable to tariff. It's a billing dispute.
I'll address on the either ways.
Huh?
Lordship, with the matter being on list.
It will be on the list. I'm not offlisting it.
on the list.
I'm not offlisting it. Okay.
Kulas, Lordship.
None appears on call for the, on the prayer made by Mr. S. Banik, learned counsel for the petitioners. Matter will be called on in the next week. The matter will be taken up in the second call in the next week. The counsel for respondent 2 has appeared and submitted that they are no longer in the matter. Which note of the said submission cannot be taken as no application has been filed by the concerned counsel. So to withdraw from the case. Therefore, the Therefore, the court is inclined to record them. There was no representation from the petitioner, from the respondent. Respondent number 2. Okay. (24/1/2023) And even today, the petitioner remains unrepresented. For injustice, the matter stands adjourned today. It is made clear that if petitioner remains absent on the next date of being called, adverse orders will follow.
Yeah. My lord, item number 5, my lord, my senior is on legs in court number 13, my lord. May I pray the matter be taken after sometime or any other day, my lord, day after tomorrow on Thursday?
Yeah, after some time, it will be better.
My lord, he's on legs on
Okay. After some
13.
time. After some time.
My lord, obliged.
6.
Three cases, Your Lordship. Lordship, the senior is on his legs at court number 18. Lordship, may kindly take up the matter after some time. Much appreciated.
7.
None of the parties are represented. For instance, this is the matter stands adjourned today. If the parties remain unrepresented, in the next part, advice orders will follow. With this matter being in part to list, it will be taken up in next call. Just his presence, Mr. N. Goswami and committed bid
1, 2 and 7 Lordship.
for respondent numbers 1, 2, and 7.
So that's on list item number 1.
You have not even described your land anywhere.
Yes, Your Worship.
Lordship,
Where is the
Lord-
land which you are holding? Where is the description of land?
Lordship, we just had one document regarding the land, and that is annexure 1, which does not specifies exactly the Dhag number where our land falls is 530. And Lordship, in this particular matter, in this
Annexure 1, which page?
Lordship, page 24,
Page 22, Your Worship,
Page
the
22,
typed
Lordship.
copy of the relevant translation partners. Sally.
But if this is a government land, it doesn't save you from eviction.
Yes, sir.
Lordship, in present scenario, Lordship, we haven't received any notice. We haven't received any notice, Lordship, but because of an imminent
You
fear
will
of
not
being
get a
evicted,
notice if it is a government land.
Lordship,
They will
but
take
we-
action under 18(2) and you will not get any notice.
Lordship, but we are seeking protection on a different ground because of our brother. Lordship, just in the month of May, my brother met an accident which resulted in a complete paralysis below chest. Lordship, I'll bring Lordship attention to annexure page 32, annexure 4. Lordship, in that particular statement, the entire procedure has been described. It's a spinal cord injury wherein the C5 and C6 vertebrae was injured, and the fracture resulted in a surgery, which
No, with this we can only direct that you will
Lordship on our part,
approach the deputy commissioner and he will consider, because we will not do that exercise.
Lordship, we may be allowed some time instead of just eviction on a straightforward part. Lordship, we may be allowed for some time for representation, which may provide us some time to even relocate on that point. As in, we are
No,
not in a
because let the deputy commissioner take a call.
Lordship, there is a fear looming over us as an eviction right might happen within this week. Lordship may provide us an interim relief on that point.
We will just give you 3 days time when you approach the deputy commissioner to take a call. So far as the interim protection is there.
Lordship, 15 days will be helpful, Lordship, as in we are not in a position to even move straightforward, as because attendant is required 24 hours with my brother, as he cannot do any task on his own. Below chest, the entire thing is paralyzed.
That's okay. We only on that reason we are giving you some time to approach the deputy commissioner. Let him take a call. Because last time a statement was made by the Advocate General that people who are sitting in their exams and those who are patients for them,
Yes,
you are
yes.
considering.
Yes. Lordship would kindly have a look at the
So
order, your Lordship. This honorable court passed in a case WPC 1156 of
So
2000.
you let him approach the deputy commissioner, let him take a call. If he has human problem, if his brother is at quadriplesis, then they have to take a.
Also, your Lordship, this particular DAG number also falls within the Guwahati Water Bodies Preservation and Conservation Act 2008, your Lordship.
This
So,
is 536. What is it, DAG number?
530, your
530,
Lordship.
530.
530, that falls within
It's-
this act, your Lordship.
Okay.
The what?
Schedule 1, 2, 3, which one?
The Guwahati
Two,
Water
Lordship.
Bodies Preservation and
Schedule two.
Conservation Act.
No,
Yes,
no,
your
Which
Lordship.
falls under
Schedule two.
Hyderabad.
Hangrabari, your Lordship. This is schedule. This
two,
is
Lordship.
schedule 3, your Lordship, Hilhaku Bill. It is mentioned in the act, your Lordship.
Schedule 2,
Schedule
Three,
triple,
Lordship.
triple 1, your Lordship, 3,
3.
Hilhaku Bill. Also, your
So
Lordship.
where is that observation that you are exempting examinations and
Yes,
those?
your Lordship, yes. That is at
Where is that observation here?
I'm coming to it, your Lordship. That will be in the last portion, your Lordship. That is the last page. Paragraph number 48, your Lordship. That was for the school students, your Lordship, who were appearing for the HSLC and higher secondary examination.
Okay, we're giving in time 7 days time you to him to approach.
Also, your lordship, another writ appeal which is pending before the honorable division bench of this honorable high court, your lordship. There also the petitioner who had filed the writ appeal against this particular order, your lordship. The petitioner has stated that she is a cancer patient, your lordship, but till now the honorable division bench has not intervened with the writ appeal. And no interim order has been passed by the honorable division bench. Also, your lordship, the writ appeal is being conducted and mainly decided on the maintainability issue, your lordship. Just for the information, your lordship.
Lordship, herein I humbly pray till our representation is being considered.
No, we can't because there is an order of this court. I am bound by this order. There is already an order of this court. That's why
Yes, your
we can merely relegate you to the deputy commissioner. He's the one who's taking a decision in the matter to consider it in terms of this order.
Yes, your lordship. Because here the petitioner's brother is paralyzed as stated in the pleadings, your lordship. So,
So deputy commissioner will have to take it
Yes,
forward.
Your
Till then, don't evict him. Heard Mr.
PR saying lordship.
P.R. Sen, learned counsel for the petitioner. And yes,
and
and
for Nagaland and
yeah,
Borderland.
Bordulai, learned government advocate appearing for respondent number.
I'm for the revenue department, your lordship. I'm standing counsel revenue department.
Standing counsel revenue department appearing for respondent number
Your
one.
lordship.
And Mr. M. Chetial and the government advocate appearing for respondent numbers
5 and 6.
2 also.
To your lordship, yes. Two, I think it's housing and urban affairs. Two also. your lordship.
2, 5 and 6. And for this,
For respondent
Three.
number 3, your lordship may kindly
Okay.
record Mr. P. Nayak's name.
okay, Mr. P. Nayak, standing counsel for respondent number 3 and 4. Next para. Apprehending imminent eviction of the petitioners in a drive which is being undertaken by the respondent authorities for clearing Silsako SIL SAKO bill area from encroachment, the present writ petition has been filed by the petitioner, namely Tin Kumani, TINKUMANI, Panyang, PANYANG. With a prayer to direct the respondent authorities from halting the eviction drive insofar as the petitioner is concerned. And to grant reasonable opportunity to the petitioner to make representation before the authorities. And to inform the petitioner as to why the land of the petitioners to be was to be acquired. Next paragraph. In case of the petitioner, in brief, say issue notice of motion returnable in 3 weeks. Requisite extra copies of the petition be served by the State and Departmental Council in course of the day. Next paragraph. Heard both sides of the prayer for interim relief. Next paragraph. In brief, cover the case of the petitioner is that he had purchased the land currently under his occupation from number 1, Deepak DWIPAK Gogoi, and number 2, Mrs. Jina Bora JINA BORA, by unregistered sale dated 21 to 1990. This is sold to whom?
Lordship, it was sold to the father of the petitioner.
Where is that? What is the name?
Lordship, his name is Vidyadhar Payan, BIDYADHAR
Okay,
PAN.
Vidyadhar Payan, BIDYADHAR, and PANYANG. This one. The petitioner claims to be paying electricity bill as well as municipal holding tax. In respect of holding construction covered by holding number capital G-392 of ward number 51
51,
of what is the road?
Borbari Road.
Of Borbari, BORBRI road by lane. Next word I can't read. Okay. It is further submitted that the petitioner has not received any notice of eviction. And the Learned Counsel to the petitioner has also submitted that recently on 11/5/2023, the brother of the petitioner, namely Ritupan, RITUPAN, PAYANG, aged 19 years, had suffered an accident and was diagnosed of fracture capital C underscript 5 vertebra VERTEBRA with cord contusion CONTUSION following fall. And the said patient was admitted in a private hospital of Guwahati with quadriparesis, QUADRIPARESIS, following fall. It is submitted that the petitioner suffered a spinal injury and has immobilized his lower limbs. And it is submitted that the petitioner requires to be protected from eviction to enable him to take care of his brother. Next paragraph. This court the learned counsel for the Revenue Department has referred to the case of referred to the order dated 3/3/2023 passed by this court in WPC 1156 of 2023, wherein a coordinate bench of this court while refusing interim relief. No, if while dismissing the writ petition, made the following observations, para 48. First of, it is also submitted that against the said order dated 3/3/2023, writ appeal has been preferred, being WA
Lordship 126 of 2023, but then your lordship, I am not sure. I have to check whether this particular writ appellant is there in the writ petition or not. The similarly situated person, your lordship. I'll have to check, your lordship.
it is submitted-
Writ appeal is 126 of
it is submitted that
2023.
the division bench of this court in WA, yes,
126.
126 or 2023, which relates to a similar matter. Did not grant any interim relief
Yes, your lordship.
against eviction process
Yes, your
in respect of Silsako Bridge, Silsako Bill. Next paragraph.
lordship would kindly record that the dark number falls under the schedule.
It is
3
also
of
submitted
the, your lordship.
that the land of the petitioner is covered by dark number
530, dark number
536,
530,
530, which is covered by
schedule 3.
Schedule Roman 3 of the
Roman 3 of this Betola Moza, your lordship, Kamrup Metropolitan District,
Betala Moja
Hangrabari Revenue Village.
under Angravadi Revenue Village of what is that act called?
That is your lordship, the Guwahati Water Bodies Preservation and Conservation Act 2008.
Guwahati. Please repeat again,
What?
Guwahati.
The Guwahati Water Bodies Preservation and Conservation Act 2008.
8. Next paragraph.
Lordship,
Having
what is
regard to
the
just a moment, having regard to the fact that in this repression, the petition has projected that his 19-year-old brother is suffering from a spinal injury, which has left him left his lower limbs in a paralytic condition, comma. In terms of para 48 of the order dated 3/3/2023 passed by this court in WPC 1156 of 2023, the court is inclined to grant time to the petitioner till 7 days will be when till 13/6/2023.
Completely, if it can be made 2 weeks, lordship, because.
No, representation was made.
uh,
Representation will make, but it will be authorities will give them time to decide. Representation have to make. Make a representation for the deputy commissioner, Kamrup Metro Guwahati, along with supporting documents. And be prepared to give an undertaking to vacate the land within such time as the deputy commissioner may, Kamrup Metro may so prescribe. The deputy commissioner, Kamrup Metro Guwahati, within bracket respondent number
respondent 5 years.
5, shall consider the representation and the condition of the brother of the petitioner and grant some reasonable time to the petitioner to remain in their, to remain in the land under the, land and house under their possession. Full stop. List after 3 weeks. You give a date after 3 weeks.
28/6.
Give them time. Tell the deputy commissioner to give some time.
She was fixed a date,
28/6.
28/6.
Next paragraph. Till till 20 in the interim till 13/6/2023. The petition shall not be evicted. Full stop. Next paragraph. The petitioner shall produce a certified copy of this order before the deputy commissioner, Counter Metro Guwahati, within the response number 5,
5
to bring the order to the notice of the said authority.
within 13/6. Your lordship may kindly mention that also.
That is there. I have already said. That one protection I'm giving it to you.
I'm obliged. Your Lordship.
Number 6.
But Ms. Bodley, please communicate.
Yes, your lordship. Yes, I
Correct.
will, Your Lordship.
It's not that
No, I will definitely.
condition of the petition, the
Yes, your lordship.
yes.
I will. Your Lordship.
Item number 6. And
Yes, Mr. Mahanta.
My lord, a very long pending case before your lordship.
Yes.
This was earlier heard on at least 2 occasions I remember to have argued the case, but for some reason or other, it was not decided. Now, government has also not come up with any affidavit here. Matter relates to a plot of land taken by the irrigation department of the government of Assam for construction of their offices, putting up
But,
their offices and all.
So far as preliminary view is concerned.
Yes.
You see, land against cash compensation or service,
Yes.
both is not possible.
No, my lord, that time that was the promise made on that count, which was at that time 74. First 74, they took one plot, then in 90, they took another plot. This is how they established their machines, houses, residential houses. quarters
Yes,
and all.
but there is no response. We'll have to give you a direction to what you call for the Mr.
Now, my lord, they,
Mr. Goswami or Mr. Setia who will be appearing in the matter. We'll have to give you a direction to acquire the land if it is a pata land which you have been using for irrigation purpose.
yes. Either to dare to pay me the compensation, or they must return it with damages, compensation. So long, initially they promised a job. I am not asking for now because it's too late.
Because you see, if you add along with possession, if you ask for damages, then I'll have to relegate you to civil court.
No, my lord, lordship will fix it. Appropriate, see, compensation is one thing. But if they want the land, if they're utilizing the land, then what should be the value? What should be the compensation I'm entitled? Otherwise also.
No,
it
that
is
will
there.
be, that we can decide. We'll have to ask them to take the recourse to the company, the what you call acquisition first.
Acquisition first.
Everything.
They ought to have gone to that. By this time, they could have done it. They have not come up with any reply. They have not taken up anything, no action. And matter is lying on.
No,
few
you see,
occasions.
there is a tacit consent. Yeah, what I read from here is
Yes.
that in 1990 this was done in
Yes.
1990.
Yes,
Your writ petition is of 2013.
yes.
So for
Because
23 years,
was-
there was a.
What happened? My lord, let us take it. Even father has given, because he was pursuing the matter also. Then that time, the children were minor. I born later on. My sisters were there. They were not provided.
I'll
any
tell you
job.
something. I'll tell you something. You see, what happens is that in there was a time I did not see those times, but I was told by people who senior people, in my family, they used to tell me that earlier land was in abundance. People just used to say that you take that land, and nobody required a sale deed to have to take a land to settle people. People used to just give the
At
land.
that time, that was the time. when
That's what I
lands
say.
were
I did not
lying
see
fallow.
those.
That was the time when government lands were in abundance.
No, I don't know.
Land.
I
That
don't
was
know,
the
but
time.
this is what I am told.
Yes.
Correct.
Even lands were given by the government also, people refuse to take. Because you have to pay revenue for that, it is difficult to pay revenue. That's
So,
how.
No, now
that
what
was
has happened
one of
is
the reasons that time.
now what has happened is that your forefathers gave that land
Yes.
without following it up.
No, he
and-
followed it up. Not that he gave it for free, no. A representation lordship will see, he filed it during
Where
his
is that?
lifetime.
This is something I missed. Where
Yes,
is that?
yes. Kindly see at page 21. This is a father's application. Yes, there is the whole thing there. Page 21, annex 4. Subject, lordship got it, my lord. It
No,
was-
this is something which is not not the original, what you call it, is not supported by any original document. It's a type copy.
Type copy, yes.
Where is the original, what you call?
Original was submitted, only copies were there.
No,
Therefore,
but
it was
where is
there.
that? Where is it?
And
handwritten
thereafter,
copy?
it was taken up also by the government authority. Kindly see the next page, but they have not denied it. This representation was acted upon next by it was written by the chief engineer to the executive engineer. To the executive engineer. Submission of proposal for land compensation of land acquired person Sri Padma Palita of Batagraba Nagaon with reference to the subject cited above. And
But,
in-
where are the copies of the document? Do you have it in your custody?
Well, the-
Only type copy has been.
Well,
submitted.
provision the committee to. It is originalized. I have one photocopy of the original.
Just show me that.
Yes. That application.
Show me that. And the this executive engineer's letter.
Executive engineer then wrote back to the chief engineer. Kindly see at page.
Show me that.
Oh, that's the original one, no? Yes. I don't think it's yeah. Gonna be next week. No, so I think for month of. It will be believed. We're gonna use it for- Pursue. No problem.
But then you have to explain the delay, you see, it's from this, from the documents.
Yes.
Especially page 24, 25.
Yes. Thereafter, I was pursuing the matter.
It's okay, but this page 25 shows
Yes.
that the construction was done in the year 1974.
74 in one part, 90 in the other part.
Where is that?
Paragraph 6 of that page.
So 74 acquisition and the rate petition 2013.
Yes,
You have to explain the delay, otherwise we'll not be.
and you see. In our petition, we have stated in paragraph 6. Paragraph 6, page 7. In the year 1990, the irrigation department again constructed a power pump station, namely Santijan ELIS number 3 in the petitioner's locality. And this time also the authority constructed a drain and the said Santijan ELIS number 3 over the plot of land covered by that number so and so, which belonged to the father of the petitioner. On 2 occasions they took and they have constructed all office houses, pump houses, all that. Now I am asking for compensation yes, in respect of the that number 420, 24, that part. Next,
But the delay you have to explain.
they are occupying it, Mala, they are using it.
No, in fact, you see, in order to, for the court to grant a remedy, a relief,
Yes.
why for an acquisition, we take the acquired acquisition without compensation which took place in 1974.
Yes.
And as you say, in 1990, we entertain a writ petition of 2013.
Yes. But at any rate, Lordship will see the land is a patta land, Yadi patta land, and admittedly taken over by the government using for the departmental use. He has been deprived of the use, occupation, everything. So government has a duty to compensate.
No, you can still evict them.
Sorry.
You can still approach the civil court and evict them.
Yes, eviction
But
for
why a writ petition?
Well,
Because,
my concern is this is a scheme established there by the authorities. The government has not disowned it. They are doing it. And admittedly, we are deprived of the benefit of the land. And there was a process initially initiated that either a job or cash compensation. Ultimately said no, job may not be possible, we will compensate in cash. Method was being pursued by the father. Then he died. Then it was pursued by him when he attained the majority. That give me a job. They said no, it is not possible.
Mr. Mahanta, that is the difficulty. You see, the statement you are making, that is creating a difficulty. You see, job or cash, job can't be given because of the Supreme Court verdicts.
That
Which say
time-
that,
that time it
no,
was
it's
there.
okay. I'm not saying.
Yes, that time it was
no,
prevailing.
now it
In
is
view of
that.
land that used to provide directly or get for
So that is one part which we can't give right now. Insofar as cash is concerned, it will be always barred by limitation. a claim for cash will always be barred by limitation. So
Always by-
therefore, but
barred by
barred by
limitation.
barred by
No,
limitation.
The cash in the sense compensation for the land is a continuous cause of action. My land, it is standing in my land, I am paying revenue, everything, they are enjoying. Government is occupying. There is a question of this limitation will not come in here. They can go for acquisition, I am entitled to compensation. If they want the properties, if they grant me adequate compensation, whatever is just and fair. But initially, suppose, my lord, I pray for a appointment post, that could not be done. But that will not absorb the authority from giving me the actual value of the property, that I have been deprived of the benefit of the land. That is what I am on.
But
Is it-
we will also have to decide, delayed release equity, that equitable
Well, there
jurisdiction
is-
can't be invoked.
There is a delay, not in my part, but delay on the part of the government. If a person, when he finds that his land has been taken by the government's authority, and he is entitled to compensation, they have also taken up the cause and processed the matter thereafter. It was not taken to a logical end. What he can do? Everybody will not rush to civil court, my lord, asking for compensation. They are not aware. They have not denied that no, land is not in our occupation, we are not using it, because it is factually correct.
Yes, Mr. Chetia. Why we should not direct a fair compensation be paid to the petitioner?
So in this case, my lord, Yan Upadhyay is appearing for the irrigation department. We are not a party also, but take my lord, land was occupied by the irrigation department from 74 by constructing. But they only opposed the authority in 1991, my lord. Before 1991, there was no objection or any application is there. If it was taken over by illegals.
Will issue a direction that if the government wants, they may, within a period of 2 months, initiate the proceedings for acquisition. If not, the petitioners will have a right to approach the civil court for eviction.
It's not
If the government doesn't want that acquisition to take place,
even without acquiring the land matter government has taken, but he can well be opposed to civil court.
we will give them that liberty.
Yes.
Civil court can't pass an order for acquisition of the land.
Yes, ma'am.
Can it be done?
No, ma'am.
No, then we can't send him to a authority with the designated jurisdiction.
In that case, my lord, their land has been taken illegally, my lord. For that, he have to initiate the appropriate proceeding, my lord, for getting compensation. Before the civil court.
You tell us, once you make that statement, you tell us you have this Land Acquisition Act. Tell us how Mr. Mohanto can initiate appropriate proceedings.
No, my lord, particular person, by the way, my lord, civil pursuit, my lord, that I am saying that, my lord.
Seal suit, we'll record your statement. We'll record your statement.
In fact, my lord, and but he is appearing, my lord, inspection may be with him, my lord.
No, no, then why you are making a statement? You don't want to vouch.
Because my lord, from the record, I have seen that
Mr.
74,
Jedia,
my lord, he
just
has-
because you want, don't say anything and everything to the court.
Yes.
Court may not be happy to accept all the submissions you are making. It may not be very happy. We will pass a stricture which will affect you. Don't do it. I allow counsel to speak doesn't mean that you can speak anything and everything. It may invite strictures which will be heavily against you. You mean to say that I will record in the court that the state is a thief who has taken over the land of the petitioner without due process of law? You want me to record that? Then can the state take over somebody's property without due process of law? No. I have different set of questions for Mr. Mahanta. I have different set of questions for you. A state can't stand up and say, you are representing a state. You can't stand up and say that he'll have to initiate a proceedings. Land acquisition proceeding can't be initiated by him. Correct. Civil court will have no jurisdiction to initiate a land acquisition proceedings. So don't make that statement without knowing the effect of the statement.
Yes, sir. I'm not saying that, my lord, his land acquisition proceedings should be initiated, my lord.
Then
He should, my lord, take appropriate because of the civil.
I have to record that he did not, Mr. Mahanta wrongly relied on the assurance of the state and did not think that the state would be a thief who will take out their property without due process of law. This is what you want me to record. I'll record it. No, don't say that. He was good enough to wait for 30 years. I may not be so liberal. Heard Mr. K.K. Mahanta and his senior counsel, assisted by Miss N. Begum, counsel for the petitioner. By filing and also Mr. M. Chetial and the government advocate appearing for the respondent number.
I am not appearing, my lord, and Upadhyay, my lord, is the
Oh, you are
because
not
of
there.
for irrigation, my lord.
Appearing on behalf of Mr. N. Upadhyay and standing counsel for irrigation department. Next, by filing this petition under Article 226 of the Constitution of India, the petitioner has paid for a direction upon the respondent authorities to initiate a land acquisition proceedings with regard to
Paragraph 2, my lord, petition that land description.
in your prayer you are saying in the schedule below.
Yes, it should be there.
In respect of 1 Katha 9 Dacha land covered by Dag number 322/420 of Pata number 284 and 77 of Batra Dawa Horu Hisa SARUHISA Hisam under Batra Dawa Moza under Dhing Revenue Circle, Nagaon. This you'll find page 4. Huh?
Paragraph 2.
Pay compensation and interest and to appoint the petitioner against vacant gate 3 post in the Water Resources Department and alternative to return and restore the land of the petitioner. And pay a sum of rupees 1 crore as damages. Next paragraph. The case of the petitioner is that in the year 1974, part of the herein before described land was used by the respondent authorities for setting up for construction of Santijan, Santijan, capital ELIS, part number 1, PT number 1. What is ELIS?
The lift irrigation project, they call it maybe electric, I cannot decide for this.
Which is stated to be lift irrigation project.
They did the water from the Santijan
Okay,
and distribute it.
it
to the people.
is. It is projected that initially a pump station was set up in the said land, and that further land of the petitioner was used in construction of a drain.
Drain and for construction of an office house.
Where is that statement? The drain, machine house,
Yes.
godown house, and a residential house.
Superior residential house is there.
Full stop. It is submitted that the father of the petitioner pursued the authorities for remedy, and after the petitioner was and the petitioner was born in the year 1979, and he took up the matter after he became an adult. This probably is submitted that the father of the petitioner, at the relevant point of time, had submitted representations pursuant to which, by letter under memo number capital CEI, full stop within bracket E, bracket closed, 115/95/339, dated 2/6/2010, the Chief Engineer Irrigation Department, Assam, wrote to the Executive Engineer, Nagaon Division within bracket Irrigation, to submit a proposal for acquisition of the land of the petitioner. Which was followed by submission of the proposal by the Executive Engineer, Nagaon Division within bracket Irrigation, by letter number capital LA/31/6/ part Roman 2 PT-Roman 2/3717, dated 19/1/2011. So it is submitted that as the petitioner and petitioner's father and the petitioner had waited patiently for a long period of time. This writ petition has been filed under Article 236 of the Constitution of India. Next paragraph. In this case, which was filed on 5/4/2013, notice of motion was issued by order dated 6/5/2018. No, sorry, 13. Notice of motion, a rule was issued by order dated 6/5/2013. And even after 10 years, the respondents have not filed their affidavit in opposition. Full stop. The learned counsel appearing on behalf of the learned standing counsel for the respondents has submitted that the petitioner may be delegated to approach the civil court for compensation. Next paragraph. Having regard to the fact, having regard to the projection made by the learned senior counsel for the petitioner, that after several representations were submitted to the irrigation department, the chief engineer, irrigation Assam, by his hearing before referred letter dated 2/6/2010, and directed the executive engineer, Nagaon division within bracket irrigation to submit a proposal, which was done by letter dated 19/1/2011. Wherein the court finds that the petitioner had done what was required of him to persuade the authorities to acquire the land. First off, it is noted that in the proposal dated 19/1/2011 submitted by the executive engineer, Nagaon division within bracket irrigation, there is a mention that, as informed by the petitioner, they were offered compensation by means of cash for a job in the department. For which no correspondence was available. Full stop. The question of providing a job at this stage would be out of question. Nonetheless, insofar as the issue of compensation is concerned, the issue relating to acquisition of the land is concerned, notwithstanding that there is an inordinate delay in approaching the court, but the court is of the considered opinion that state cannot be permitted to take shelter of the law of limitation to deprive a citizen of its right to have reasonable land compensation for a land which was used by the authorities for public purpose without acquisition or requisition under the either under the Land Acquisition Act from 1894 or under the Assam Land within bracket requisition and acquisition bracket closed Act 1964. Full stop. Ordinarily, the court, while exercising jurisdiction under Article 226 of the Constitution of India, is also a court of equity, and that usually the court invokes the doctrine of inverted commas, delay defeats equity when it comes to institution of a writ petition after cause of action, in the year 2013, when the cause of action arose in the year 1974. Full stop. Nonetheless, comma. In this case, the respondents have not denied, have not filed any affidavit in opposition to deny that the land was acquired without due process of law. The respondents have not also taken a stand that the land was offered to them without expecting any consideration. Under such circumstances, comma, the court is of the considered opinion that under that as the land of the petitioner, comma, which is a patta land, was used by the respondents for creating a public asset in form of a lift, pump, etc., for a lift irrigation system, comma, the petitioner would have a reasonable right to have the land acquired by initiating a process of land acquisition, which was entitled the petitioner to a fair compensation and nothing more. Full stop. Next, insofar as the prayer for employment is grant of employment is concerned, the court finds that the said prayer is not in accordance with the scheme of public employment, which is prevailing in the state of Assam, and therefore the said prayer is rejected. Next paragraph. Insofar as the claim of the petitioner for compensation is concerned, comma, the court is of the considered opinion that the said issues ought not to be examined in a writ petition under Article 226 of the Constitution of India, as determination of compensation would require some amount of examination of evidence and evidence, both documentary and oral. And therefore, if the petitioner seeks to prosecute the matter for monetary compensation, it would be open to the petitioner to invoke to approach the covenant civil court. If so advised, and subject to law of limitation. Next paragraph. In view of the discussions above, the court finds that the petitioner has a right to have his land acquired either under the Assam Land within Requisition and Acquisition Act, 1964, and or under the right to fair compensation. Give that full name, right to fair compensation so Act. As the court finds that the petitioner is entitled to a fair compensation, in accordance with the acquisition laws. Full stop. In this regard, the petitioner shall produce a certified copy of this order before the chief engineer within irrigation, Assam, and the said authority to take steps to initiate a land acquisition proceedings in accordance with law. If the land acquisition proceedings are not initiated within a outer period of 6 months from the date of service of certified copy of the order, comma, it would be open to the, no, it will take time because it goes into the various channels to reach that stage.
How much is enough, I suppose, for that?
No, it will not be more. You see, there will be a preliminary notification, then a final notification.
They will have to go for all the process, but they will have to take the call first.
That is-
Yes, that is,
in
it's a
fact,
process.
if such initiation is not done within the time, within the time allowed, comma, it would be open to the petitioner to move the civil court for eviction of the respondents in accordance with law. And other it is good, and other is in accordance with law. I'm returning you back this petition stands allowed to the extent as indicated.
But it may also, I think, add that the regarding compensation part I had made the prayer. It can be taken care of in the acquisition proceeding itself. That proceeding.
No, acquisition is for compensation only.
Yes.
No, but you are asking damages in
Damages.
1 crore.
Damages separately. It is not automatically paid. if
No,
they
no,
do
no,
not
no,
do-
not that. Once you have made the prayer, I have to say
Yes,
something.
yes.
Or
Yes,
if you,
what you said rightly. Let the liberty will be there.
compensation is not there.
That's it.
It's compensation, solution and interest.
Yes.
That
So
forms
the
a part of it.
all will come in the process.
That will
execution
form a
process.
part of it, but damages in form of compensation.
Yeah, that is something different.
I'm returning you back your documents. 2 documents you gave me. I'm returning it back.
Yes. At least this has seen the light of the day after a long time. I'm grateful to you. All right.
I was inclined to dismiss it.
The fortune prevailed in his favor, my lord, he has suffered a lot this. All right.
Yes.
Item number 8.
My lord, we are for the respondent.
Yes.
Yes, from the petition.
You were there earlier also. I think let us wait till the next week, otherwise we'll say that it is not taken up next week. None appears on call for the petitioner. However, Mr. R. Hussain does counsel for respondent number 7.
I'm for respondent 8, madam.
And Mr. M. Sahibala then counsel for respondent number 8.
I am for respondent number 12.
Mrs. R. Yadav, Mrs. K. Yadav, then counsel for respondent number 12. And Mr. M. Chettiar, government advocate for respondent numbers
1 and 5.
1 and 5 are present. First off, it is provided that for instance, this is the matter stands adjourned today. So it is provided that if the petitioner remains absent, then the matter is taken up on the next call in the next week. Adverse orders will follow. Yes, here the government who's for forest. Forest will be required, just a moment. I think in this case,
Forest is not a major part.
no, it's required because somewhere I read it's a reserve forest.
Yes, my lord.
It's a reserve land. So what reserve?
Reserve forest area,
Is it reserve forest?
some part, yes.
Some, so therefore, SC forest, Mr. Das. Just wait for some time. Because then we will proceed, if it's a forest, reserve forest, if I read it, then we will proceed to hear the matter, irrespective of the petitioner. Just wait for some time. Deputy Commissioner, respondent number
My lord.
5.
Yes.
Yes, filed affidavit, your lordship. He has stated that the settlement is already on process settlement, they are trying to make. Now it's proposal and now it is settled also. And it is due to this erosion in the river, the land was wiped away by Brahmaputra river and that's why they will settle in the other place. They are having, all are having their tea cultivation in that area. And this petition is otherwise not mentionable, your lordship, they kindly see, only on the basis of the newspaper report, he has filed this petition that allotment should not be made to the respondent. But the persons whom he has named in the writ petition, he has not made them party. Only few of them he has picked and choose, he has made party. Your lordship, they are
It's
party
okay,
in the
we'll see that. But first of all, we must find out if this land is reserve forest land.
There are working of the writ petition. There. He stated so many.
No, it's some of the documents you say, I won't remember it because I never read it with any intention. There's a document here which says that the land, a part of the land is a reserved land.
Which part and part cannot only because.
No, it's there, but I'll be able to find out. Just give me 5 minutes, I'll be able to find out. It says that it's a part of the land is a what do you call reserved land. If that is so, then we can so take it up. Even if the petitioner is absent, we'll appoint a amicus curiae and proceed with the matter.
Your lordship, it is the annexures, your lordship may kindly see page 23. Page
No,
20.
not this, not this. There's a specific document saying that a part of the land is a government reserve forest land.
Yeah, that is also on the basis of the newspaper report.
No.
And the letter they have written to the government.
My lord, reserve area is under rule 43 of Assam Land Revenue.
Just a moment.
In my affidavit, reserve for this road, not.
No,
reserve.
I don't know. I found some documents saying it's a reserve. Land is said to be reserved. Ah,
Page 26, my lord,
23.
23.
no, page 38. It's a question and answer of 14/12/2012 in the Assam Legislative Assembly. Short-term question number 55. Here, P's ministry has answered star question mark 218. So and so regarding encroachment of khas land, forest land, and wasteland. The answer is regarding 3 is yes. The star mark question number 219 by the minister regarding 3 revenue circular Dhaka, the Dhokakana constituency. B, as per information received by Deputy Commissioner Lakhimpur concerned, circle officers are directed to take steps for eviction. Then there's one more document. It says reserve, but what reserve I don't know. Ah, yes. Page 31 of the affidavit filed by respondent number 7. You see, it starts from page 30 and it says that tea estate under Kadam Revenue Circle, Sintola Tea Estate, government khas land. Ananda Tea Estate is government khas land. Seruziri Tea Estate is Siling acquired government land. Sinatola Tea Estate is reserved land. Sijuli Tea Estate is reserved land. Ananda Tea Estate is reserved land. If that be so, we can so to proceed against them. We'll ask the Deputy Commissioner to do it. What is the nature of reserve? Reserve has to be a what you call forest reserve. Otherwise, you don't know. That's why I said what type of reserve I don't know, but it says it's a reserve land. Just wait for some time.
Yes.
Let the forest department be there. That's why I said somewhere it is there. Somewhere it is there. The reserve land is there, but where I don't read that much thoroughly. It's after some time.
Number 9.
Non-efficient call for the parties. For instance, just the matter stands adjourned today. The petitioner remains absent on call on the next date. Advisory orders may follow. Just right there, as the matter is already in the hearing list, huh? Party list, if the petitioner remains absent. This will follow. And yes.
Very short temper.
Other matters I may not take up. Just only one left out matter. Other matters in part 2 I may not take up.
But you will also be very similar. 16 to 2006, 13 letters of land was given to the petition.
Just a moment. Just 1 minute.
Yes. It is in very short temper.
Yes.
During the petition, during the pendency of this suit, we filed an appeal before the Board of Revenue and it took all the relief. This is the case in short. 2006, my lord, your lordship will note 16 to 2006, government allots 13 letters of land to the petitioner. Now petitioners, I think father. Now their names have been substituted. His son has become the petitioner now because petitioner died. And page 26, your lordship, the suit filed by them starts from page 19. So this is the suit and the relevant is at page 26.
Okay, who is the plaintiff?
I'm the
You are the plaintiff.
So they are seeking, my lord, a decree declaring the mutation, allotment and settlement of Schedule B land in the name of Sri Pulan Fangshu as illegal and nullity due to previous allotment of the same land to the plaintiff society. So this was a dispute going on. Petitioner, the plaintiff said, my lord, they were allotted about 4 kathas of land in their favor. That out of these 4 kathas, 13 letters has been allotted to the petitioners.
Yes.
Now, page 27, your lordship can read. This is the disputed thing. A plot of land measuring 13 letters out of 4 kathas, 16 letters land of Schedule A covered by Dag number so and so. So this is, he wants to set this aside back. Declare this as a nullity and illegal. So
What has happened to the suit?
It's going on, my lord. It's pending, my lord.
Still going on.
Yes, still going on. And
Because
there is a stay, I think. Now, lordship, can you see that they filed a miscase there, and the miscase there is an order, page, my lord, 47. Relevant, your lordship will get it at page 48, third paragraph.
Yes.
Third paragraph, being the recorded partner in respect of Schedule B plot of land, defendants have every right to enjoy their property unless restrained by due procedure of law. And as such, I am of the considered opinion that allowance of the petition in respect of Schedule B land will cause irreparable loss and injury to the opposite party number 1 and 2, which can't be compensated in terms of money. And whereas rejections in respect of Schedule C land would place the plaintiff petitioner in more convenient stage. Whereas the injunction order in respect of so and so land is concerned, defendant opposite party 1 and 2 have not filed any objection in respect of the players issuance of injunction and as the remaining portion in the possession of the land. And as such, I am of the considered opinion that opposite party number 1 and 2 would not face any inconvenience or would not suffer any injury if the injunction is granted. Accordingly, the order of temporary injunction is issued restraining defendants from entering into and cause disturbance in respect of the portion of land of Schedule A. Schedule A land, my lord, we do not have objection, but in respect of Schedule B, This is the order of injunction, and they have denied. They say B land has been allotted to the petitioner, so we should continue. Now, in this circumstances, filed a appeal before the Board of Revenue. That your lordship will find page 49. And petitioners, my lord, they have filed objections, etc. Now, page 83 is the order of the review.
Page
83. Board of Revenue, my lord. Board of Revenue, my lord.
cancel your pata.
Yes, cancel the land settlement during the pendency of the suit. This they cannot do by submission, my lord. And therefore, it's a res judicata, my lord, the matter is pending before the court below, where the suit has been filed by the opposite party as plaintiff, and where the injunction has been denied in respect of 13 letters of land schedule being Schedule B. So therefore, the order passed by the Land Revenue Board is on the face of it is not maintainable. And more so, my lord, I am just placing one judgment. My lord, the Revenue Board do not have any rights for. We have gone through the relevant, we agree with the learned advocate that there are no provisions for filing any appeal against the order of settlement. But the matter is pending before the court below. In the suit is pending. So during the proceedings of this suit, once the injunction is denied in respect of Schedule B land, they cannot go to appeal where the appellate Revenue Board doesn't have the jurisdiction to pass any.
No, that can't be accepted for the time being. You
Yes.
see, the reason is very simple.
Yes.
This order of injunction
Yes,
was passed on 4/9/2012,
yes,
correct?
yes.
This Board of Revenue, when they went, we don't know. It's 135 RA of 2012,
Yes,
whether before or after.
17/5/2013. This is during the pendency, madam. Pendency of the suit. Plaintiff, your lordship,
Where is the application before the Board of Revenue?
Board of Revenue is 23/8/12.
49.
Yes, 23, page 49, 23/8/12.
So 23/8/12, it is
Yes.
before that they went.
Yes. No, before. Plaintiff, my lord, March 2012.
Plaintiff is March 2012.
Yes. And the injunction was denied on 4/9/12.
4/9/12. So
12.
after, before that, where they went.
Yes. Yes. Before the order of the Revenue Board passed the order on 17/5/13.
No,
17.
but the application before the Board of Revenue was prior to the suit.
No, it is after the suit. That is, plaint was filed on March 2012.
Okay,
Plaint was March 2012. There is an order before the, my lord, the injunction order is before the order passed by the Revenue Board.
it's okay, but when was this filed?
Suit was filed in March 2012.
Okay, but when was this revenue case filed?
Revenue was filed on 23/8/12. Page 49.
23/8/12, okay.
Yes. And they do not have the right, the jurisdiction to, against the order of settlement. That order is there. Besides this, the suit is pending, injunction denied. How can appellate talk to Revenue Board decide the matter? Suit is pending, let suit continue. Under section 147, my lord, one cannot file appeal against the order of settlement.
No, it's not acceptable. So that's because of the reason you come to this judgment you have cited.
No, no, I'm not on the judgment. Basically, my lord, the judgment is there against an order, my lord, of allotment, or the revenue board doesn't approve. That is besides.
No, but this also will not be applicable because you see what had happened here. Come to paragraph before that, the mark, we have gone through the relevant provision.
Which one, man?
This judgment you have given.
Yes,
You see here,
Yes.
the land was acquired under Assam Requisition and Acquisition Act 1964.
yes.
So therefore it says that and the rules made under the act for filing of appeal against the order of allotment and subsequent settlement to the board. So it's a settlement of the acquired land.
Acquired land. But it says, my lord, against the order of allotment, my lord, one cannot go to the board. Board doesn't have the power. Under my lord, regulation 147, board, this is besides, my lord, besides, my lord, res judicata, my lord, because the matter is already before the suit. Suit is there, my lord, how can they decide the matter? They have filed the suit. Injunction has been denied. That is prior to the order of the revenue board. That order was, the injunction order was by 1880. Four 9/12, and the revenue board has passed the order on 17/5/13. Cancelling my order of settlement.
Here what had happened was that the land acquisition was made
I'm
under.
just showing that, I understand.
Uh-huh.
I'm just showing. Besides, well, because the revenue board doesn't have the power against the order of settlement. That is there. Order of settlement, revenue board doesn't have any power. Who says? Under 147. That is besides, but I'm mainly on the fact, my lord, that the order of.
Because you see,
injunction-
if there's an order of settlement,
Yes,
against then the civil court jurisdiction is barred.
that is different thing, but the suit is going on and the order of injunction has been denied. And the suit is proceeding. How can they go to appeal and the revenue board pass an order?
No, did you take a plea that the suit was pending?
Yes, yes.
Where is that?
The petitioner's objection is there at page 60,
Page
60.
60. Yes, where is the defense taken up for the civil case pending?
Yes. Paragraph 10.
Which page?
Regulation 154. Civil court jurisdiction is bad.
Please come here. I did not hear you.
According to him, he says 154.
154 of the regulation, land acquisition regulation.
No, you see 154. I'll tell you what. 154 will not be applicable here. I'll tell you why. Subject to what Mr. Das and Mr. Bhattacharya says.
Page 64, man. Regarding suit.
One, just a minute.
the
Oh,
page
yes,
64.
yes, you are right.
Yes.
154A, 1A.
Yes.
Question is validity of any settlement. The civil court will not have jurisdiction. So it can decide the title.
Yes. It's regarding a cancellation of settlement. Hello.
We should have come to High Court. Under
Which one?
226. Under 226.
No. Against this order of settlement, there is a appeal provided for before the government,
Government
Yes, they should have gone there.
before the government.
But the land, appellate, land revenue authority, they do not have any. Page 64, your lordship will. tell us,
Just a moment.
we have taken this pendency of the suit and all. Yeah, I think it has been discussed by the revenue. We doesn't discuss about suit and all.
Commissioner would mean Mr. Bhattacharjee,
Yes, my lord.
against this settlement rules.
Yes, my
In the settlement rule, the commissioner means deputy commissioner or is a commissioner of
commissioner,
divisions?
the commissioner of division. My
lord,
your lordship will see here the case is.
No, just a moment. Is it commissioner or divisions?
Division commissioner, Assam administrative tribunal is commissioner. That is your lordship will find to section 26 of the Land Revenue Act, my lord. Confirmation and cancellation of settlement.
Yes,
It says,
26.
yes.
It says commissioner. That's what I'm
Yes,
asking.
that is a commissioner.
Commissioner means divisional commissioner.
Yes. He has the right to cancel the patta if there is an.
So the board of revenue will not stand.
The board of revenue is there, my lord. He is governed by the commissioner, my lord. He has the power.
No.
My lord, that is.
Board of revenue is a board of revenue.
Board of-
Commissioner
that
is a commissioner of divisions.
But board of revenue, the appeal lies, my lord, for cancellation of pattas.
You can't lie.
But my lord, that is, I'll satisfy your lordship. That is. Your lordship will come to the judgment, man. Stay away, man.
Mr. Das, you have anything more to say?
Page 64, the objections we have said about the title suits.
64, okay.
But objection starts from page 60, it doesn't note anything.
Yes, Mr. Bhattacharya.
Yes,
Yes,
page
should come to
64.
the judgment of
Page
the,
64,
my lord, of the Board of Revenue, my lord, that is 83. Page 83 of the petition there,
Yes,
my lord, from the very beginning. My lord. This is an appeal against the grant, against the issue of the KP Patta in favor of the respondent number 1 by the settlement officer Guwahati for the disputed land. The case of the appellant is that they are the registered society involved in the social work as a plot of land measuring 14 kata 16 lassa covered by that number so and so village, Angrabari, was reserved in their name by the government order dated 26/5/1990 for the construction of office building. The said land was handed over to them on 13/7/1990. Your lordship may note that. After taking the possession of the land, they have constructed their office building over the same and have been using since then. On 22/7/11, the respondent number 1 with some person tried to occupy the 13 lessons of leased land of the above mentioned 4 kata 16 lessons of land as reserved and handed over to them. The appellant obstructed them and filed the FIR with the police station. They came to know from the police station that the respondent number 1 has obtained a periodic patta for 13 lessons of land from within the land. Hereby that means, my lord, without giving, they have settled me the land. Government has settled me the land in 1990, my lord. Without cancelling that land, my lord, the government settlement officer in connivance with this pattadar, means the petitioner, has taken 13 lessons of land. They have settled in their name, my lord. That's finding is there, my lord. I'm just coming up. They came to know from the police station, so and so. The other litigations are in progress in the other forum of law. That is admitted, my lord. That civil suit is going on. The appellant has filed this appeal for cancellation of patta. Your lordship may note that the cancellation of patta issued in favor of the respondent number 1 from the land they have already given to the appellant. Now I'm coming to the next point. The respondent claim is that the government in the revenue department by an order dated 16/6 issued an order of settlement of 30 lessons in favor as he is a landless. The settlement officer issued the patta in his favor based on the settlement by the government. He has objected to the claim of the appellant on the following grounds. The appeal is time-barred as the settlement order was 16/6 when the whole, while the appeal was filed on 12. The order of the government dated 26/5/90, wherein 4 kata 16 lessons was settled in favor of the appellant, had a conditions that the land must be utilized within 3 years, failing which the same would be reverted to the government. The appellant have constructed their office building on the other part of the land reserved in their favor and have not utilized the 13 lessons which is unutilized stood reverted to the government, and so government was within its right to settle in its favor. Now, my lord, the appeal has been admitted keeping the issue of limitation open. Looking at the circumstances of the case, it is evident the appellant could not have known that the government has issued an order setting 13 lessons of land in favor of the respondent number 1 from within the land already reserved in their favor under their occupation. They could have not known only after the respondent number tried to take the position of the same and prevented the legal claim overhead. In view of this delay, the delay stand condoned. Coming to the merit of the case, the facts are not disputed. It is admitted situation that 4 kata 16 lessons land were reserved by the government in favor of the appellant in 1990. The same was handed over to them and an office building has been constructed over it. The appellant has been in possession of the land since then. The claim of the respondent that 13 lessons of land had not been utilized, so the stood reverted to the government, is not even worthy of comment. Nobody is required to construct a building over the entire land. If the building has been made over to the land and the condition of the government letter reserving its stand fulfilled. Even otherwise, if the government felt that the condition was not fulfilled, the entire land of the entire Fort Cutters would have been taken by them. It cannot be deemed to be a small portion of it to divided as no building was constructed on a part of land. It is not understood. Your Lordship may note. The government could settle 13 lessors of land out of 4 Cutters 16 lessors that have been given to the appellant. The land was no longer a Sarkari. After settlement with me, my lord, this land doesn't become a Sarkari,
Where is the order of settlement?
my lord. I'm coming to that, my lord.
No, your order of settlement.
My order of settlement.
After your order of settlement, actual settlement, what you call payment of this,
Everything was done, my lord. That is in 1990. That is in 1990.
you paid the premium
Yes,
and
yes,
you,
everything, my lord.
where is that? This is something
is
which I am not getting.
This I have to produce that document one later on. Because it is in the judgment, it is stated, my lord. It was produced before the Board of Revenue. On being satisfied, that last portion, your lordship will see what it stated, my lord. The land was no longer a Sarkari land. Whosoever, your lordship may got that point, my lord.
Yes, I am
Page
there.
84, last paragraph, my lord.
Yes.
It is not understand how the government could settle 13 lessons of land out of the 4 Cutters 16 lessons of land that has been given to the appellant. The land was no longer a Sarkari land. How whosoever in the government has done, it has committed a crime and need to be prosecuted.
No, you see, I will not follow it unless you show me. You see,
My
come,
lord, that I have to produce it later on. Because it is-
come to page 50.
yeah, 50
Nowhere, this is your 49 is your appeal
appeal.
under 147.
Yes,
Nowhere there is a statement that the land was what you call patta was issued in your name.
yes, revenue appeal.
Yes, patta was issued in your name. I did not find it. Everywhere it is said it is settled. But the patta was, you see, the Board of Revenue is giving a finding
Yes,
that it was a land standing in your name.
yes.
But where is that the stand of yours?
Page 21, your lordship.
I'll find it.
Page
It's a part of
21.
the pledge.
Sita.
Because page 21, yes.
It is a part of the pledge. Considering the activities of the plaintiff society, the government of Assam White order dated was pleased to reserve 4 Cutters 6 lectures of land of village.
No, that is okay, but patta is issued.
Patta is not being.
But
But my lord,
because
in
my
short
lord,
point is, my lord, when injunction has been refused, how can they can go to appeal? It is a very
my
short
lord,
question according to me.
I will see sometime given, my lord, I will produce those documents, my lord. But here is the
No,
case, my lord.
you see,
Yes, my lord.
accepting of documents at this stage is
No,
very
my
difficult.
lord. As your lordship has made a queries whether it is settled with me or not.
No, because
That is with in the Board of Revenue record is there, my lord. If your lordship call it, it will be seen
no,
there.
it's here, it's available here.
Yeah, lordship will find out. It's there. I think so. Without that documents, my lord, how
LCR, LCR I have not seen.
lordship will see.
You need to show me the document because you see, unless that settlement is converted into a patta, even few days back in a matter, I refused to accept it. That tennis association.
No, I'm not on that one. That's a different issue altogether. They may have, and they, so far I did not get it. But when the matter is pending before the a suit has been filed by them, then a revenue board passes on. They will be-
Yes, yes, my lord, there's a
Suit
decision.
will, you see, suit will only decide the title.
Yes.
So if supposing what happens if the title is refused, then what happens? The Board of Revenue order will prevail because under the against the order of settlement.
Board of Revenue, my lord, when they came to know the objection was filed regarding the denial of the injunction petition, they should not have decided the matter. It's a res judicata. They filed a suit regarding the same subject matter. And then they go to the appeal matter.
This is what I understand. And appellate authority doesn't take into consideration the objection filed by us, showing that the suit has been filed and all those things, and he has got on their own.
My lord, I will submit a
He doesn't have any
judgment
jurisdiction also.
in 2004, my lord, wherein this is even 154, under the 154, the civil court has the jurisdiction of it. Well, Lordship will go through that.
It's a different matter. Well, when the-
You see, if you make that statement, it is easier for me to allow Mr. Das's matter. if the civil
According
court-
to me, it is as simple as that.
If the civil court has jurisdiction,
No, not
then-
has jurisdiction. They filed a case there. It
no,
is
no,
pending.
no.
It is not my
He says
case.
that can be decided by civil court. If that be so,
No, it
then
cannot
we-
be decided. That's a matter which we will take there. We may take a plea before the civil
Well,
court.
this
that
law-
This
this-
suit is not maintained.
Huh?
That is our case, man. Maybe our case. The suit is not maintained, you go anywhere else.
Your Lordship will see this, my lord.
no, Mr. Das, that is unacceptable for two reasons. Number one cannot be without remedy.
No, the remedy has been filed before the suit. Now we are not.
No,
going to
now you
decide.
are saying that you even that you dispute. You
No,
see,
no,
somebody
suit has
will
been
have.
filed. Suit, how can I dispute? All the documents are there.
Yeah.
Suit is filed, injunction.
No, that's what I am
refused.
saying.
Yeah.
That if the suit is there and he makes a submission that the suit will decide it,
The suit
then
has
board
to
of
decide.
the board
Suit
of
has to
revenue
decide.
order otherwise will also not be.
They cannot go to revenue board, my lord.
My lord,
For the purpose of-
Yes.
My last paragraph, my lord, from what has been stated above, we would say that in a matter like this, like one at hand, the civil court jurisdiction would not be barred in the following cases. Whether the order under Rule 80 is patently illegal or without jurisdiction, where the remedy provided by the regulation to adjust the objection raised is not sufficient, where the complicated question relating to the title are involved, or where the plaintiff seeks declaration of title over the land from which he is sought to be evicted, my lord. As to the point 3 and 4, we would like to state the assertion of title must be the genuine and not a mere pretext. A bona fide claim of having title and not having only a husk of title. So this means the civil court has the jurisdiction, my lord.
That's all right, my lord.
This has the jurisdiction, because here also I have asked for the right title interest, my lord.
Then
And-
board of revenue can't adjudicate.
My lord, yes, my lord. That two part I have said. This is 151. Even if I file, my lord, the title, civil court has the jurisdiction to decide that. This
It's
is
okay,
from
then-
154, my lord.
Then the board of revenue will not prevail.
My lord, that I accept, my lord, because here the revision they have gone against the 154. In the 154, that is why the court has says. Even in the 154 also, the civil court has the jurisdiction to decide these issues, like a title declaration. Because here is the case, my lord, where the land was allotted to me without giving any notice to me. They have taken away 13 lessons. I have to, after paying all the premiums, my lord. And that is the issue herein, which the civil administrative land revenue board has the jurisdiction. Because without
Just so.
is 22. My lord, in the record, I have remarked it, my lord, that position and everything was handed over. Annexed 2, my lord.
No, handing over position is not the query of the court.
Yes.
The court query is whether a patta has been issued to you.
My lord, I
Handing
have-
over position is something else.
Yes, that's right.
Even in this case of what you call 2 days back, I have decided this tennis association. They are also not even handed over. The tennis stadium has come up.
Stainless.
Even after that, I have said that the right of the government
My
will
lord,
prevail.
I'm not on that matter. What I am on, my lord. Allotment was given to me. before cancelling the taking away the land, they must give me an opportunity. That the opportunity was not given, my lord.
It's not required.
My lord, it's required, my lord. Principle of natural justice is there, my lord,
Not
because
required.
I have constantly constructed the land, my lord, on the land. That is the finding, my lord. I have
You
already
see,
constructed over the land.
You see, I am bound by my own orders.
Yes,
And
my
a few days back, I held for tennis association, that tennis stadium. What is that? What is that name? Tennis stadium case? What was that?
What is that?
Surusya Stadium.
That is where near the bypass, my lord.
So,
So, yes.
So they have said that I have upheld the authority of the government to issue a notice of eviction, not to give notice, because of the fact that the government has what you call the land stands in the name of the government.
Yes.
And therefore is not entitled to a notice.
My lord, that is a stand in the name of the association government. Here, the government has given that allotment. Your lordship will see annexure 2.
There also, not even the government gave allotment. The stadium, entire funding of creation of that tennis stadium
Yes.
was given by the government. Each and every paisa by which the stadium has
Yeah,
come up.
my lord, government has right to take away, but there must be a reason, my lord.
No, not required.
My lord,
Yes, sir.
here when the settlement was cancelled, my lord, prior to that 13 lasas, what does make them to cancel the 13 lasas, my lord? Why not the entire land? Why not the 14.13 lasas? Only 13 lasas? Because functions.
I may not be required to answer that.
Yes. No, my lord. What I'm saying, my lord, because one of his brother is an IS officer. That is what reflects in the judgment itself.
Okay. Okay. That's all. Heard. Mr. Bigdas and the senior counsel, assisted by Ms. Hardekar and counsel for the petitioner. For the substituted petitioners. Mr. M. Chettiar and government advocate appearing for respondent number 1. And Mr. K. Bhattacharjee and the counsel appearing for respondent number 2. 3 is revenue. Ms. Mr. K. Gogoi done its standing counsel for the revenue department, respondent number 3. N. Bordulai, okay, Miss N. Bordulai, standing counsel revenue, respondent number 3. Next para. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 17/5/2013 passed by the Assam Board of Revenue in Revenue Appeal number 135 RA within bracket K bracket close public 2012. Mrs. Bhattacharjee, you were saying that you could satisfy the court that the appeal was maintainable From where?
From my lord.
You said that the appeal was maintainable before the Board of Revenue.
Yes, yes, my lord. I have given that one, my lord, the decision of 2004 and also my lord 1999.
No, no, this says that the civils would have jurisdiction.
Yes. The
That the
civil
Board of Revenue has jurisdiction to entertain appeal.
My lord, against the settlement order, my lord, it is always the Board of Revenue, not the
Where is
commission.
that? Where is that?
My lord, that I have to find out. Just. My lord, your lordship will come to the section 147, 3, surplus 3, my lord.
Yes, what does it say?
Say an appeal may be admitted after the period of limitation prescribed thereof by this section when an applicant satisfies the board or officer to whom the appeal he had sufficient cause for not presenting the appeal within that.
No, that is limitation.
That is limitation because here also delay. I have filed it.
No, no, limitation. I'm not on limitation. I'm the board's power to entertain appeal.
My lord, when the limitation has been admitted by the board, my lord, naturally the appeal has to be heard by the board, my lord.
Jurisdiction and condonation of appeal is something else.
My lord, this is clear, my lord. Appeal, my lord, that is provision is there.
Where?
My lord, when an order has been passed for non-renewal notice to the annual patta holder or directing them to show cause why the legal
You
proceeding
are reading where?
2, my lord. Section 2 of the 147, my lord.
147?
147 of the land revenue, Assam land revenue regulations, my lord. Authority to whom appeal lies. From there one.
Yes.
Yes, my lord. To the board from the order original applied by the Deputy Commissioner Settlement Officer and revenues. A 147A.
147?
A. Authority to the.
No, no, you see allotment letters, if I understand correctly, since I have not dealt with so long time, I've forgotten. Settlement orders are passed by the government.
By the, so the settlement officer.
No, no, no.
Now government, with that we have to deposit the money to the government, then they.
No, but order of settlement.
Yes,
you see the order of settlement to Mr. Das is by whom?
By the settlement officer.
Can't be.
That is what,
17, page 17.
that is also that is given by the settlement officer, not by the government. That is the funding of the tribal board also, my lord.
No, no, no,
It
no.
is some settlement officer has done this. Yes,
No, no, no,
page
no, no.
17.
Page 17, Mr. Das is right. It is by the Secretary of the Government of Assam.
Secretary Government of Assam, my lord, the order was passed through the settlement officer. They have, my lord, the order was, here proposal has been sent through here to settlement for settling the patta, my lord.
That is something else.
Yes, ma'am.
Proposal may be sent by a peon.
Yes, ma'am.
We are not on that.
Government has allotted that.
So against the order of the settlement, you have filed an appeal before the Board of Revenue. I am just asking you, where is the provision? Against the order of settlement,
Yes.
if you file an appeal, I am just asking you, where is that provision?
Order of settlement has not been challenged.
Well, the settlement, government has passed the order.
See the
Settlement
appeal.
officer has.
Appeal, there is no order of settlement. Order of settlement, it is in the plain tone. Order of settlement, where is the appeal? Page 49 is the appeal. I did not find anything, man.
No, there is a provision I forgot.
I got your lordship is some time.
so no.
Because I also remember my lord, because when the government
Cancellation
allotted the
of the
land,
patta number.
it is the
for order of settlement.
because he has to deposit the money before the government, then only the settlement will be given, my lord. Those procedure has to be followed, my lord. Once it has been settled by the government, then he has to pay the money and then only the settlement order will come.
On receipt of the money by the government,
Then only the settlement order will come.
settlement order comes from the government, and then the Deputy Commissioner merely writes an order to the effect, giving effect to the government of settlement and records in the
That is the
patta.
that is agreement. That is the procedure.
Okay. And the petitioner has also prayed for a direction to the respondent authorities to rescind, recall, and or otherwise forbear from giving effect to the order dated 17/5/2013 Just on that, has challenge out of this so and so. Next. In brief, the case of the petitioner is that by an order dated 16/2/2006, the Deputy Secretary to the Government of Assam, Revenue within bracket settlement bracket close department, directed settlement of the land with the petitioner, with the predecessor of the substituted petitioners, namely Pulen PULEN, Pangcho PHANGCHO. Full stop. The respondent number 2, by claiming that the petitioner had encroached and entered into 13 lectures of land, 13 lecture land,
Yes.
13 lectures out of his allotted
4 kata 16.
4 kata 16 lecture land, filed a suit being TS number 101 of 2012 for declaration of right title and interest, recovery of khas possession and permanent injunction, as well as cancellation of patta and with ancillary prayers. Full stop. Along with the suit, the petitioner also preferred an injunction application, and the Court of Learned, Munsif number 4, Kamrup, Guwahati, by an order dated 4/9/2012, restrained the petitioners, restrained the predecessor of the petitioners from entering into the Schedule A land, but excluding the land of Schedule B till the disposal of the suit. Full stop. Schedule B land was Schedule B land is the 13 acres of land settled in favor of the petitioner. Full stop. On or about this land revenue appeal was filed when
23/8/12.
23/8/2012, the respondent number 2 filed an appeal before filed an application under section 147 of the Assam Land and Revenue Regulation of 1886, read with section 151 of the said regulation before the Assam Board of Revenue, where it was registered as revenue appeal number
Number 135 RAK
revenue appeal number 135 within bracket RA
K
within bracket K
no,
of 2012, along with an application for condonation of delay. Full stop. Full stop. The Assam Board of Revenue heard and decided the matter on 17/5/2013, which is the the matter by order dated 17/5/2013, while condoning the delay, held that the pata issued in favor of the petitioner over 13 acres of disputed land was illegal and was cancelled. By further holding that the letter dated 16/2006 issued by the government to settle the land in favor of the petitioner, predecessor of the petitioner, be treated as infructuous, having been issued beyond jurisdiction and a part of fraud which deserves prosecution. Next paragraph. Assuming the said order, the learned senior counsel for the petitioner, for the petitioners, for the substituted petitioners, had submitted that when a suit regarding right title interest is pending adjudication before the jurisdictional court, i.e., Court of Mercy number 4, County of Guwahati, an appeal before the Assam Board of Revenue could not have been preferred by the respondent number 2, who is the plaintiff in the said suit. First off, it is also submitted that against the order of settlement, affiliate jurisdiction is not available to the Assam Board of Revenue, which is not vested with the power to entertain such appeal. Full stop. It is also submitted that when the civil court did not grant an injunction with regard to the Schedule B land, i.e., the 13 acres of land settled in favor of the petitioner, the respondent number 2 had approached the Assam Board of Revenue. Next paragraph. Per contra, while opposing the prayer made in this petition, by referring to the case of Tuniram Katoni, Tuniram Katoni, and others versus Gulap Gulap Chandra Katoni Katoni, within bracket 2004, bracket closed, 3 GLR 641. It is submitted that notwithstanding his stand that the appeal before the Assam Board of Revenue was maintainable, even the civil court jurisdiction was not barred to decide title involved in respect of the suit property. Full stop. It is also submitted that as the Assam Board of Revenue had passed an order in interrogatory application filed under section 147 of the Assam Land and Revenue Regulation, 1886, the Assam Board of Revenue would be vested with the power and authority to admit an appeal. Next para. The under the Assam Board of, under the Assam Land and Revenue Regulation, comma 1886, comma the power of the board to entertain an appeal you can call out from the from the provisions of section 147A of the said regulation, which provides that appeal shall lie to the board from orders, comma, original or appellate passed by the deputy commissioner, comma, settlement officer or survey officer. Full stop. In this case, comma, as per annexure 1 to the writ petition, comma, the order of settlement was passed by the government through it's deputy secretary through the deputy secretary to the government of Assam, revenue within bracket settlement bracket close department. Full stop. Next paragraph. As per the provisions of section 4 of the Assam Board of Revenue Act, 1962, the board is vested with power and jurisdiction to entertain appeals and petitions and revise decisions in revenue cases arising out of the provisions of enactments specified in Schedule A to the said Act. Full stop. As per the book, the court is holding, the Schedule A enumerates the following acts: the Opium Act, 1878, appeals or revision against order passed under sections 23, 24, and 25, Assam local rates RATES regulation, 1879, Assam Forest Regulation, 1891, within bracket appeals in matters of section 11, 12, 13, and 14, bracket closed, revisions under section 20 of arrangements made under section 13 to 16. This is under forest regulation, 1 to 3. Then 4 is Assam Motor Vehicles Taxation Act, 1936, within bracket revisions of orders under section 17. Bracket goes full stop. And number 5, the Assam Motor Vehicles Act, 1939. Within bracket appeals against the order of state transport authorities under several clauses, sub clauses of section 64. Under several clauses of section 54. Stop. Be that as it may, as a detailed argument has not been heard on the power of the board to entertain an appeal no conclusive finding of the court is returned in this regard. In view of the opinion of the court expressed hereinafter. Next paragraph. Insofar as the decision of this court in the case of Tuniram Katuni and others in the bracket Supra is concerned, the court finds that there is a reference to the full bench decision of this court in the case of Daulatram, Daulatram, Lakhani, within bracket 19, sorry, the Daulatram Lakhani versus State of Assam and others, within bracket 1989, bracket was 1 GLR 131. Where after discussing several case laws on the point, the full bench of this court had held that the civil courts, civil courts jurisdiction would not be barred, amongst others, where the plaintiff seeks declaration of his title over the land from which he is sought to be evicted, or where complicated questions relating to title are involved. First off, in the present case in hand, the said ratio was followed in the case of Tuniram Katuni within bracket Supra. So in the present case in hand, the respondent number 2 had approached the civil court by filing title suit number 101 of 2012, which is stated to be still pending for adjudication before the court of Munsif number 4, Kamrup Guwahati. Is still in Munsif 4, and amongst others, one of the pairs of the petitioner, of the respondent number 2, is to declare right of the respondent number 2 society to hold and possess entire Schedule A land as lawful allotted of the government of Assam. Full stop. Therefore, when the issue of title is being adjudicated before a court having jurisdiction conferred to decide title, the decision of the impugned decision of the board, Assam Board of Revenue, dated 17/5/2013 in case number 135 RA within bracket K of 2012, will not be allowed to prevail. First, it is also noted that in the objection filed by the petitioner before the Assam Board of Revenue, a statement has been made to the effect that the petitioner had appeared before the court in TS number 101 of 2012, and that injunction was refused by order dated 4/9/2012 in Ms. J case number 190 of 2012. And it was specifically mentioned in page 5 of their objection that the appellant, i.e. the respondent number 2 herein, cannot claim same relief before 2 forum. And also played that the appeal was liable to be dismissed on principles of sub judice. Now, of res sub judice. The said aspect of the matter is found to have not been considered by the Assam Board of Revenue in the impugn order. Therefore, the court has no hesitation to set aside the order passed by the impugn order dated 17/5/2013 passed by the Assam Board of Revenue in case number 135 RA within bracket K of 2012. Next paragraph. It is made clear that nothing observed in this order will prejudice both sides. Should TS 101 of 2012 is decided in its own merit. The LC next paragraph, the LCR we send back to the Assam Board of Revenue.
And that impugn order stands set aside.
Which one?
The revenue board order. Revenue board order.
That has been set aside.
Set aside.
That has been set aside. This decision I am not referring because otherwise I have to reject this proposition.
They're all waiting for other.
Huh?
Court can seat up to 7 million.
No, I should not. I should not. Forest has not come. We'll take up some other day. Mr. Gogoi or Mr. Setia, if you find counsel for this forest, you tell him this matter we are deferring today. It will be heard some other next week, some other day. Not on Friday, not on Thursday. Next Tuesday, I think we'll take it up. But this reserve forest, that I want to understand. If it is a forest reserve, then perhaps even in the absence of the petitioner, we would like to proceed with the matter. So he must have instructions. You give your copy. He can take a copy of this part 2 file and peruse.
Regarding reserve forest, in the morning hours, also.
Yes, that's why. Only on that reserve forest, which he will have to explain. He's not a party, but he will take the here. Mrs. Yadav, Sir Hussain, next Tuesday we will take it up. You should not. You may not wait for the entire week. This matter will be taken up on Tuesday. Make it Tuesday. Tuesday will be 13/6/2023. Here is right. Petitioner remains absent on call. All the respondents are represented. Issue has arisen as to whether any part of the land involved in this rate petition is a part of reserve forest land. The presence of the Standing Council for Forest Department is also required. The learned Mr. M. Chittiar and Government Advocate shall inform the Standing Council for Forest Department. The matter will be taken up in the next call on Tuesday. That regards that order. Okay.
Dog number, I think, is full.